102 A and B.
All right, and Mr. Cremines, you're representing Mr. Wheeler.
It's going to be Mr. McCown, Your Honor. I did enter appearance on his behalf. We've got a notice of appearance to file today, waive reading, enter a not guilty plea, and ask for an OR bond.
All right, there'll be $1,000 OR bond. Do you know Mr. McCown's schedule?
I don't, Your Honor. I would say probably anytime about 3 to 4 weeks out at the court's schedule.
The 24th of February?
That should be fine, Your Honor.
All right, February 24th will be the pretrial at 10 o'clock. February 24th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Nikki Wheeler, case number TRC 23-104 A and B.
Same as last case, Your Honor. Mr. McCown, have to waive reading, ask for a enter not guilty plea, and ask for an OR bond.
And she can sign a $1,000 signature bond,
Sign right here.
and I'll set it the same date then.
That'd be fine, Your Honor.
February 24th date for pretrial. 10 o'clock, not guilty plea is entered.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Joseph O'Malley, case number TRC 23-103 A, B, and C.
And sir, are you Joseph O'Malley?
Yes, sir, Your Honor.
Mr. O'Malley, the state's filed a complaint alleging that on January 28th at 3:14 a.m. in Union Township, you were driving a vehicle under the influence of alcohol or drugs or a combination, and that you refused to take any tests. It's alleged this is your first time, this would be your first conviction if you were convicted. On a first offense, the maximum penalty you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. There is a minimum penalty the court can't go below if you're convicted, and that's 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the minimum penalty on a first offense OVI. You understand the charge and possible penalties?
Yes, Your Honor.
Then you've got another charge of driving outside your lane. That's a minor misdemeanor. Carries a maximum penalty of $150 fine. Those are the 2 charges. Do you have any questions about these charges?
No, Your Honor.
Do you have any questions about your rights?
No, Your Honor.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed to represent you?
I'm not sure yet if I'm going to get one or a court appointed yet, but
Well, if you want to hire your own, I don't have to ask you any questions about your income. If you want me to consider appointing you a lawyer, I have to determine what your gross annual income is.
okay. Trying to think if I might. I'll get a court appointed lawyer for now.
Okay, are you working?
Yeah. Yep.
What do you do?
I work for a logistics company, like for like FedEx, Lasership,
Are
stuff
you
like
paid by
that.
the hour?
No, I'm daily. So
How much are you paid on a daily basis?
anywhere from like $200 to $300.
Okay.
Depends on what I'm doing that day.
Well, do you know do you file income tax returns?
Yeah, but my last year I'm making a lot less now than I did the year before. So last year I probably made like 70, I would say.
Do you have dependents?
Yeah,
How many dependents?
5.
Children or spouse? What?
4 children.
Okay, do you think you're making less than $50,000 a year?
This year it'll be close. It'll be right around there.
Okay. Well,
It's hard to say, to be honest. We're kind of going through a change in the company right now, so
do you have money saved?
not much.
Do you own real estate?
I own a home.
Okay, I'm not going to appoint a lawyer for you at this
Okay.
time. I'm going to let you try to get counsel.
Okay.
Okay, there's another charge that I failed to see previously. Yeah, there is a C case. It's expired registration. That's also a minor misdemeanor.
Okay.
Maximum penalty is $150 fine. Expired plates is what that is. So that's another charge you have. Okay, I want you to try to obtain counsel on your own. If you want to come back and fill out an affidavit and get me some information about your actual income, some
Okay.
written documentation, then I can look at it. But the cutoff for someone with your family size is roughly $50,000.
Okay.
You know, I have a schedule I have to go by for
Mhm.
court-appointed counsel, so that's what it's going to be. You have to have less than $50,000 a year income to get court-appointed counsel. So I'm going to go ahead and enter a not guilty plea for you. I'll let you sign a signature bond, which means you're signing a document that says you promise to come to
Okay.
court, or you'll have to pay $1,000, and you get a warrant if you don't show up. That's the worst part, but you'll owe $1,000 for not showing up. And I'm going to put it out till the 24th to give you a chance to try to get a lawyer. If you don't think you can still afford one and you want me to reconsider, bring me some documentation on your income.
Okay. You said the 24th?
February 24th, there will be a pretrial at 10 o'clock. Do you have any questions, sir?
No, Your Honor.
Okay, that's all.
All right, thank you.
You're welcome.
State of Ohio versus Colton Carpenter, case number CRA 21881.
All right, I think this is Mr. DeLauder's case, and he is here, so we need him in the courtroom. Chris DeLauder, please.
Phil.
All right, Mr. DeLauder, are you representing Mr. Carpenter?
Yes, I am, Judge, and I spoke to the prosecutor about this morning. We may need Mr. Heald in here. I believe the state, there he is. This was an alleged incident that happened back in 2021. The state's contact information doesn't appear to be good anymore anyway, and there haven't been any further problems. I believe Mr. Heald's willing to dismiss the case today. And if there happens to be a further problem, they would have the right to refile it.
That's all we're saying. I don't have any comments.
All right, so the case will be nollied without prejudice.
Thank you, Judge.
You're welcome.
State of Ohio versus Stephen Kingery, case number TRC 21656 AD&C, CRB 21797.
All right, and you're Stephen Kingery?
Yes, sir.
All right, Mr. Kingery, it looks like you missed a hearing back June 10th of 2022 on this OVI. Well, it was actually two OVIs. No, looks like just one. Okay.
Yes, sir.
Both had the same case number, 21656. Okay, do you admit or deny you missed your hearing?
I admit.
Do you have an explanation for missing?
No, last time I was here, you said to get my life together and come back, so I've got my life together.
Well, I'm sure I would have said come back on the date that you were supposed to come back for a review hearing. You're supposed to be here June the 10th of 22 for a hearing, and you've got stuff you didn't do. You've got community service you were supposed to do, fines and court costs you were supposed to pay. And I think at that time, you had a problem in Cabell County, and Mr. Sowers was going to take you over there.
Yes, sir.
So did that all get resolved?
I still have to pay some money. Your fines will be paid today. I talked to Mr. Cooper, and the community service will be done in about 2 weeks.
Okay. All right, so what I'm going to do now, you've got a bond up again with Mr. Sowers.
Yes, sir.
You just posted yesterday.
Yes, sir.
So I'm going to put you back on the docket in about a month, and we'll see what you can do. You got stuff to take care of. So March the 3rd is going to be your next hearing, and it'll be a sentencing hearing, actually, because he has a bond up now. So if you don't show up now, Mr. Sowers will come and pick you up and make sure you're here. So get this stuff done.
Yes, sir.
See, there was actually, there was a drug paraphernalia was the other charge, right? There was a CRD 21797. That was just a $50 fine. But, okay, you've got both of those to take care of. Both are set for March the 3rd at 10 o'clock for sentencing. Get your stuff taken care of.
Yes, sir. I'll be here.
All right,
Thank you, sir.
you're welcome.
State of Ohio versus Brian McClellan, case number TRD 182552, A, B, and C, CRB 16200, TRD 161,007, A and B, TRD 143549, A and B, TRD 101638, A and B.
Okay, Brian McClellan is here. You had a review hearing on Monday, I think it was. Yeah, Monday.
Yeah.
You missed. Do you have an explanation for that?
Yeah, my daughter, she brought a flu home from school and made the whole family sick, so I didn't take a chance coming.
Okay, what have you done since your last hearing?
I paid all my fines.
Okay. Did you do that today?
Yeah,
How much?
25.
Yes. Okay, I have verification of that. It looks like your community service is done. Okay, March the 3rd will be your next hearing, 9 o'clock.
Thank you.
You're welcome.
State of Ohio versus Caleb T. Ham, case number CRA 21327.
Good morning, Your Honor.
Good morning.
Mr. Stratton.
It's just, I think that was his one more time. All right, you were supposed to be here Monday for a review.
Yes, I've had so many court dates and stuff going on, I honestly just forgot I had it Monday.
Hey, man.
How you doing, sir?
Okay. This is actually a review hearing, so you don't have to.
Oh, okay.
You don't have to participate in this.
All righty. Just a review.
Thank you anyway, man.
Okay, you've got fines to pay.
Actually, I got an interview with Stilla, West Virginia next week, and I'm hoping to get that stuff in gear in the next 2 weeks and start paying on fines.
Okay, well, if you can't pay it, you can work it off community service. You've got to do
Okay.
something to take care of it.
Who would I talk to about that as well?
Mr. Cooper,
Okay.
I'll set your next hearing February 27th. Start taking care of stuff. Get this done, you can quit worrying about coming to the review hearings.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Chester Fugit, case number TRC 22798, A and B, TRC 22664, A and B.
Okay, this was set for a week ago for a review hearing, and it looks like you were not here. You admit that, or
Yes.
do you have an explanation?
I had a CT scan from a specialist at King's Daughter saying, I called and asked them about it, and they told me just to keep the appointment to have the scan done and to come here today.
Who told you that?
Girl in the office.
Well, if they did, that would be wrong information. I mean, you should reschedule the CT scan. This takes precedence, but you're here now. Do you have a payment on your fines?
My fines are all paid, sir.
Okay. That looks correct. You got community service to do.
Yes.
Okay, when are you gonna get that done?
I'm gonna try to get it done within the next couple of weeks.
Okay, it's a 22K, so I'll give you about 6 weeks to get this done. You should get it finished then. If you
Okay.
do, you don't have to come back.
Okay.
And make sure you've got everything else done.
I gotta do a driving class or,
Oh, yeah, you gotta do the 3-day school too.
Yes.
Maggie is here from the 3-day school. I want you to talk to her, get that done. When's the next schools?
March the 16th to the 19th.
Okay,
I could
so I'll
pursue.
set this for March 24th. If you do that weekend, get your community service done, you don't have to come back. Because that's all you got left to do. March 24th is your next hearing, 9 o'clock. Talk to Maggie about the 3-day school, and you're free to go. Maddie, I'm sorry, I said Maggie, Maddie.
Thank you, sir.
State of Ohio versus Chad Reynolds, case number CRA 2484, CRB 2485, TRD 142166.
Chad Reynolds. You had a review hearing. Guess we had a lot of people who didn't show up Monday, so you're here today. You admit missing Monday.
Yes,
You got a reason for missing?
not a good one.
Okay. Well, good, don't tell me. Because a lot of people want to tell me bad reasons. I'd rather just not even hear it.
It was my mistake. The program manager actually told me I had court Monday, but I wrote it down wrong compared to what I had told him when I went to court last time. I thought it was today, so like I said, it's not a good one. It's my fault.
Okay,
May I approach you?
yes. Well, at least that's refreshing, because we don't have too many people admit it's their fault. Most people want to say, well, it was this, it was that, it's not really my fault. That's standard procedure these days. Okay, it's a really good report. You got a job, and it sounds like you're in position to get an even better job.
Yes, sir.
Okay. That's all wonderful. Okay, I'm looking at your files. You've got 1 day of community service left and a small amount of fines left.
Yes.
So, how do you feel about things?
I think things are going good. Feel like my recovery is doing really well. My life is getting straightened out. You know, I've got a decent job right now. I'm in line to get a better one. And I'll have this paid here in a little bit. I tried paying a little bit ago, but couldn't pay with card. So she told me I could get online and pay it, or I could bring cash back. And community service, I'll have that done. I thought that was complete. I thought I had all 3 days complete. So I went there and talked to her this morning, and I'll either do it tomorrow, but they probably won't let me do it on Saturday, so I'll have to do it on Friday most likely.
Well, you can do it here on Saturday, or your employer won't let you do it, or?
My program manager, we have groups on Friday or Saturday mornings.
All right, well, from my perspective, you're doing really well. So I just want to say that. You got things going the right way. Got to keep working at it.
Thank you.
And looks like you're about to finish up here. You won't be coming back here much longer. So just know that that doesn't mean you can let up. I mean, this is something you're going to have to work out. You know, okay? But so far, so good, really good.
Thank you.
Okay, let's make and is it better as far as your work? Monday or
Friday would be the best.
Fridays?
Yes.
March 17th.
Thank you.
March 17th, 9 a.m. Okay, good job.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Corey Little, case number CRB 22491, CRA 22405, CRB 22407.
Okay, this is still an active case. And Mr. Holt's your attorney, right?
Yes, sir.
I don't know, is he on the docket? Okay. See if he's here yet. Okay, Mr. Little, just have a seat. Your attorney is scheduled to be here, so we want you to talk to him, and after you've done so, we'll recall you before the court.
I've been asked to let everybody in the court know that you need to have your phones on silent. Turn your phones on silent. And Your Honor, I am mistaken, Mr. Holt is not on the docket today.
Oh, okay. All right, Mr. Little, you may as well come back up then. Mr. Holt's not going to be here. Let's get Mr. Field in. All right, this is Corey Little. He has active cases pending, and there's been a warrant outstanding for him since August the 8th of 22 on domestic violence, 22407, possession of drugs, felony level, 22405, and 22491. Violation protection order. So I don't know if you want to pull your files. Mr. Holt's the attorney. He's not scheduled to be here today. Looks like Mr. Little did get arrested on the warrants and posted a bond. Is that correct, sir? $4,500. $4,500 bond.
And, okay, so there's a protection order in place which he's accused of violating, so we do have the protection order. I can get the file.
You want to try to text Mr. Holt?
I can do that, and it might be a situation, since he's already posted bond, we just wait till Mr. Holt can be here. I don't know if he's scheduled for today or not.
He is not on the schedule today. All right, so I'm going to let the prosecutor pull their file. I'm ordering you not to depart the courthouse. We'll let him try to get in touch with Mr. Holt and see how they want to proceed today. Just have a seat and we'll recall.
State of Ohio versus Kara D. Summers, also known as Kara Hearn, case number CRB 2381.
Ma'am, are you Kara Summers?
I am.
Ms. Summers, you've got a theft offense filed against you, alleging that on February the 2nd, at the Walmart in South Point, in fact, that's Fayette Township, you tried to deprive Walmart of property without their consent. That's a first-degree misdemeanor theft offense. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
I understand the charge.
Do you understand your rights?
I don't know what to plead.
Well, were you here when I explained the defendant's rights?
Yeah.
Well, remember what I said. If you don't know what to do, enter a not guilty plea.
Okay.
That's the safest plea you can enter. So you want to enter a not guilty plea?
Yeah, I'll enter not guilty plea.
Do you have the money to hire a lawyer?
No.
Are you working?
No.
I'll appoint Mr. Stratton to represent her. Okay, well, I'm going to give you a lawyer to represent you.
Okay.
And you do have a bond up.
Yeah.
This is Kara Summers. It's a theft from Walmart case. My instincts tell me that she needs an assessment. I'm really afraid of letting her out on bond without an assessment.
I'm really nervous right now. I don't come to court and...
So do you want to talk to her and see if maybe she's agreeable to that and come back and I'll finish up bond? She has a bond up, so that's sufficient to guarantee her appearance, but I'm just afraid of what's in the community. If I let her out, something bad could happen before she gets back to court.
Sir, I stay at home with my son, and
I think Mr. Stratton understands what I'm getting at, so let him talk to you and consider it, and we'll come back and you can discuss everything off the record. All right, thank you. We'll recall this for bond later.
State of Ohio versus Corey Little, case number CRB 22491, CRA 22405, CRB 22407.
So that's the same one. We just had that, false alarm, have a seat. We'll put it here in this set. Let's put it in this set.
That's all we have. So we're ready for pre-trials.
Okay, we're ready to start pre-trials. So we'll need the prosecutor and defense counsel to come in court.
State of Ohio versus Courtney Beater, case number TRC 22890, A and B.
Your Honor, we were here previously on this matter and came to an approved recommendation for the court on Ms. Beater. She's done and completed the 3-day driver intervention program, and I believe the state, if she, on a change of plea, is going to recommend an amendment to physical control with a $150 fine and court costs.
Okay, I do see she completed the driver intervention program January 12th through 15th.
And that was our prior agreement, which we had presented to the court, and we're willing to do that today.
Okay, it'll be amended to physical control, and how does she plead to the amendment?
No contest, Your Honor, stipulating to guilty plea.
All right, do you agree with what your attorney has represented to the court, Ms. Beater?
Yes.
Do you have any statement or explanation you want to make to the court before I conclude them? Okay, I'll propose what was recommended. We need to work on this because it's not, I used to be able to control these from here, and now it's not, it's just being controlled from that computer. Okay, $150 fine and court costs.
She's going to pay that today, Your Honor.
All right, see the clerk won't impose any probation.
Was there any statement of the turn signal?
There was a turn signal also.
Plead to that.
Same plea to that, Your Honor.
All right, $10 fine on the turn signal.
Thank you, Your Honor.
Thank you. See the clerk.
State of Ohio versus Angela Kelly, case number CRB 22787.
Angela Kelly is Mr. Means' case. Go to people. There where it says people. Click on that. You should be able to. See, it won't, for some reason it won't let me either. Okay. Go to gallery view. Okay.
Your Honor, I spoke with Mr. Hill, and he's made an offer. If we could come back maybe on the 24th as well for another pretrial, I can relay that to you or discuss what that is and figure out whether we're going to need to, whether there's going to be a plea entered at that time or we're going to set a trial date.
Okay, there's a time waiver to that?
Yes, Your Honor.
All right. At the finished request, case is continued to February 24th for a pretrial at 10 a.m.
State of Ohio versus Philip Kratzenberg, case number CRA 22809.
It's Mr. Permine's case set for preliminary hearing, looks like.
That's correct, Your Honor.
Approach on.
Yes. And the reason it's charged with felony is because of the exam. Because I don't know the circumstances. But otherwise, all right, defendant wants a chance to talk over some things, so case will be called later in the docket.
State of Ohio versus Devin Stevens, case number TRC 222682.
This is set for pretrial today.
Your Honor, if it please the court, this is one of there were 3 cases that arose out of the same incident involving 3 different young men. And after a thorough investigation of the circumstances, including a discussion with there were at least 3 highway patrol officers involved in this situation too. We determined that as best we can, how everything happened. And we don't believe that under the circumstances that Mr. Stevens should be charged with an OVI. However, there is one young fella involved that we feel like we can prove a case against. So we would dismiss the charge against Devin Stevens. And it's not our intention.
The reason the state wants to do this is because you don't have proof beyond a reasonable doubt that Mr. Stevens was actually operating a motor vehicle.
That's correct, Your Honor.
And there is also agreement that Mr. Stevens will give truthful testimony in any other cases called upon.
Well, we would issue a subpoena for him to do that. Now, one of the other young fellas that's involved in this actually gave us a statement, and we've arranged for that in that case. In this case, if we needed him, we would issue a subpoena for him, but we don't believe that maybe he has the same level of knowledge of what happened as the one who gave a statement.
All right, based upon that, I'll allow the case to be nominated.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Destiny Anderson, case number TRC 22-665, A and B.
All right, this is Mr. Murray's case, and he is appearing by teleconference. And it's, actually, I can't see him. Can you hear me, Mr. Murray?
I can hear you. Can you hear me?
Yes, but not very well. We'll try turning up the volume here.
Can you hear me now?
Okay, that's much better, much louder.
Sure.
Okay, so this is set for a pretrial. Has there been any discussions with, between the defendant and the prosecuting attorney?
Your Honor, we have received a discovery demand, and we've answered that, but we have not had a discussion yet. But I would be willing to state on the record what our recommendation would be if there's a plea, as soon as I locate the file.
It's Destiny Anderson.
Well, I don't have the file in front of me. I'm sure it's
Okay,
in
you
here
wanna
somewhere.
recall it?
If we may.
Okay, we're going to recall this. Mr. Murray, let the prosecutor, who has a wheelbarrow full of files on his desk, locate the file and we'll recall.
I just found it.
He's got it. Okay, so it's recalled right now.
All right, so this is a second offense high score. So it carries with it some serious consequences. So what I would ask to be able to do is to have a conversation with her attorney. We've answered discovery. He may want to look over the discovery, and I would arrange a telephone conference with him, and we can discuss what he may feel that we need to do.
All right, Mr. Murray, anything you want to say?
No, Your Honor, not at the present time. I appreciate it though that the offer could be made, at least the offer could be made in a conference room or via telephone.
Yeah, I'd be happy to do that. And I've got a phone number for Mr. Murray.
Okay, so I'll let counsel have that discussion. I see there was a motion filed today for occupational driving privileges. Since this is a second offense, my reading of the law now requires it has to be 45 days from the day of the offense, so I don't know if we're past that. There is at least a 45-day waiting period. There has to be, so we're probably there. This was November. There has to be special plates and ignition interlock required for driving privileges on a second offense now. So, what's the state's position on driving privileges?
If the amount of time has elapsed, we don't have an opposition to it if the court felt that it was appropriate under whatever the law requires.
So I'll let you, Mr. Murray, discuss that with your client. State's not going to oppose it if she meets those conditions that I set forth. So do we want to maybe reschedule this for another pretrial after counsel's had a chance to talk?
Yes, Your Honor. And what I'm going to do is I'm going to have one of my assistants contact his office, give him my cell phone number so that we can communicate easily. And we'll try to do that before we come back again.
All right, Mr. Murray, could you hear what Mr. Heald said?
Yes, I could hear what he said. Your Honor, if I could interject with my client, he's a very responsible person. He's state tested nurse's assistant. So she's working now at the veterans home. And for her age, I think that is, I believe this is the first offense charge of this. So I would ask the court to keep that in mind as the prosecutor. Thank you.
Okay, well, I was going on the prosecutors. The allegation is that it's a second offense, that there was a prior in 2022, and that this is a high test score. So those things that I said before about the requirements for ignition interlock and special plates, those are all requirements if it's a second offense. So, and that's the allegation, is that it is a second offense.
The prior is Chesapeake Mayor's Court, so we would reserve judgment on whether that makes this a second offense or not.
Okay.
But I would ask to speak with Mr. Murray when we can talk off the record, and maybe we can talk about how to resolve the matter.
Okay, so it's possible, and I'll let you look into that, Mr. Murray, that it was an uncounseled plea at a court not of record, so that would have some weight. But I'm also concerned, just to let you know, I'm concerned. The allegation is she tested 24. That's a very high test. So that gives me some pause about giving her driving privileges. So, let you and Mr. Heel discuss it. If you want to come back fairly quickly, then maybe we can take up that issue.
And, Your Honor, one thing I'd like to add is, that, and it is concerning for us as well, because of the score itself and the fact that this is a second, whether it would be considered a second for sentencing or not because of the mayor's court, that we would be recommending some sort of substance abuse counseling and treatment as a disposition regardless of what happens. So it may be that she would want to take part in that, get started on that for her own benefit.
Okay. Mr. Murray, when would you want to reschedule another pretrial? It could be Monday or Friday. It wouldn't make much sense to do it this coming Monday because I don't think probably you'll have a chance to talk with Mr. Heel before then. So we could either do it next Friday, the 10th, or the 13th. Okay. We'll reschedule this for a pretrial on February the 13th at 10 a.m. And Mr. Murray, you may attend by teleconference if you wish.
Thank you, I appreciate that.
All right, anything else?
Well, Mr. Murray, I'm going to have my assistant reach out to you at your office, and I'll have her give you my cell phone, and you can text me, and we can start a conversation that way, if that's okay with you.
Certainly.
Okay.
All right, next hearing, February 13th, 10 o'clock.
And also, we need a time waiver, if he's willing. You okay with the time waiver, Mr. Murray? Just for the period of the continuance?
Did you hear that, Mr. Murray?
No, Your Honor, certainly could you repeat that?
I'm asking for a time waiver for the period from today until February 13th.
Certainly, Ms. Anderson, you have the right to a speedy trial, and it's a first-degree misdemeanor charge, and you're out on bond, and therefore, you have not 90 days to be tried, but obviously, the trial will go beyond that time. It's my recommendation that way, do away with the trial, and if that, able to, Ms. Anderson.
Could you understand what he said? You have a right to a speedy trial to be tried within 90 days. The state's asking that this time, next 10 days be not run as part of that 90-day time frame because it's kind of at the request of the defendant to evaluate things. And he's recommending that you agree to that. Okay, she shook her head yes. So we'll take that as a yes. There is a time waiver until February 13th will be the next hearing. At that time, we'll hopefully have some conversations that have occurred between the state and the defendant. Okay, that'll be the next hearing. Free to go.
Thank you, Your Honor.
Thank you, Mr. Murray. You're welcome.
Thank you, Your Honor.
You're welcome.
I need for you to call their office and give myself.
You're free to go, man.
State of Ohio versus Gavin Davis. Case number TRC 222681.
Yes.
Judge, this is
one of the other companion cases.
This is a companion case Mr. Hield spoke about. Mr. Davis did, by way of statement, inform the state of Ohio about the events of that evening. I provided that to Mr. Hield and told Gavin that, they may have further questions or he may have to come up here for further proceedings, and he understands that.
All right, so this is the one where it's going to be knowledge because there's not sufficient proof he was driving, but he will agree to give truthful testimony also in exchange for the knowledge.
That's correct, Your Honor.
All right, case is knowledge.
Thank you, Judge.
You're welcome.
State of Ohio versus Joseph Foster. Case number CRB 22545.
Approach on this one.
Yes.
Judge, this is the case, Mr. Cremines represents the alleged victim. They are going through a divorce, and we reset this today thinking the divorce would be over, but we weren't able to get a court date in time. So we think we will be able to get it put on the record before February 27th. And there's an agreement in the case. There haven't been any further problems. The parties have gotten along. They divorced agreeably. And there's an agreement to nolly the case, but we just don't want to nolly it until the divorce is over.
Okay, this is 22 CRB 545 Foster, and there's an agreement to continue it to the 27th of February.
If that's okay with the court.
And there is a time waiver.
Yes.
To be set for February 27th for pretrial.
Thank you, Judge.
You're welcome.
State of Ohio versus Michael Shore. Case number CRB 2315.
Yes, this is Mr. Delauder's case.
Judge, on this one, this is a dogs running at large case. I've talked to Mr. Hield about it this morning. Mr. Shore insists that these two animals are not his dogs, they're strays. He also has agreed to cooperate with the dog warden in trying, they're a nuisance to him too, so he wants them gone also. He's agreed to cooperate with the dog warden to try to make that happen. We've asked you to move this to February 27th to allow the state time to get a hold of the dog warden and set something up so they can come try to catch these dogs.
Okay, Mr. Price case is continued to February 27th for another pretrial at 10 o'clock.
All right, thanks, Judge.
You're welcome.
May I approach him?
You're moving on.
Thank you.
You're welcome.
State of Ohio versus Peyton Anderson. Case number CRB 22766.
Smith's case set for pretrial.
Your Honor, if it pleases the court, this is a case that originated here as a felonious assault or complicity to felonious assault. Actually went to the common pleas court. Further discussion and further proceedings were had there, and I'm really not sure exactly why it was determined to come back here, but it was determined that we should refile it as a simple assault, a misdemeanor assault. And since then, there's been a resolution between the individuals involved. One of them, I believe, was a juvenile that was involved. And the parent of the alleged victim has let us know that since all this has happened, that they're all young people, and that his lesson has been learned and there have been no further issues. And she would be satisfied if we offered a plea to the regular misdemeanor assault, 30 days suspended. Would be our requested disposition, and then probation. There's no request for protection.
That's correct, Judge, that's what we talked about. This is a case where the kids were having a backyard wrestling match. My client videotaped it, got out of hand, so I guess that's why it came back as a felonious assault, came back down here. But we would ask you to adopt that as the sentence in this matter. He will change his plea to guilty based upon that recommendation. Right, Hayden?
Is that correct, Mr. Anderson?
Yes, sir.
Do you have any statement you want to make?
No, sir.
Did this happen at school, or was this at a private residence?
My residence. I think it's near the school, Judge.
Are you still in school, or you're out of school now?
I'm out of school.
All right, I'll impose a $100 fine on court costs, 30 days in jail, all suspended. I'll make it level 5 probation. Set a review hearing for September 5th. Just has to pay the fine and court costs. Needs to see Mr. Major in the probation office. No protection order.
September 5th. When you leave, there's also to the left, probation.
State of Ohio recalls Brandon Delosi, case number TRD 221764. CRB 21766, CRC 213000, A, B, C, and D, CRD 212268.
Okay, Mr. Wosi, this is actually a review.
Okay.
You have been as counsel.
I had been, that's why I thought maybe I missed something. Thank
Do
you,
not
Judge.
have a report from OVP. I do now. I texted them. They texted me back that you are attending your sessions as you should. So that's good. I'll set your next review hearing. I'll make a March 17th. It's your next review, 9 o'clock.
Thank you.
You're welcome.
State of Ohio versus Kaylee Bennett, case number CRD 22643, CRD 221604, A and B, PRC 22170, A, B, C, and D, PRC 202681, A, B, and C. Haley Bennett.
Haley Bennett is Mr. Smith's case.
Yes.
Set for pretrial.
He should, what his name is. There's a cross filing judge.
Who's the other?
Hold on,
Who's your lawyer?
Mr. Morford.
Mr. Moore.
Mr. Morford's speaking to one of his clients on the phone who's in the jail.
What's this?
Mangum.
His name's Khalil, but I think it's on there wrong.
I guess I can speak about Mr. Moore. The agreement was, Judge, it's been a while, 90 days, or how long's it been now? I think it's ready to be dismissed today, or upon payment of one court cost.
Yeah, from October 24th, we agreed that if there were no further problems between them, that we would agree to a dismissal upon payment of one court cost.
Yeah.
There were no protection orders. So we're willing to stand by that.
Now, she still has other cases.
She did the DUI, I think we sentenced her on that already.
She's sentenced, but she's
Yes.
review hearings.
Oh, yes, sir, yes, sir.
And there hasn't been anything paid.
I have a $20 payment to make today, and I haven't done my community service yet because I was working Monday through Friday from 7 to 3, but I just changed my schedule so I could start doing that. I only work Monday, Tuesday, and Wednesday now, so I can do that on Thursday, Friday, and Saturdays.
We have community service on Saturdays too.
Yeah, that's what, he just now told me that, I didn't know that.
And Judge, she cannot pay a day. I don't know if we want to set a date, and if she pays by then, it'll be dismissed without her showing back up.
Let's get the other case first.
Oh,
Go ahead,
State
Paul.
of Ohio versus Khalil Mangum, case number CRA 22645 and CRB 22646.
This is Mr. Morford's case.
We'll dismiss both cases in one court. I guess it doesn't matter who pays, because you'll...
Let me see.
Yeah, that was my notes, that with one court cost and no further problems, cases will be dismissed.
They would just need time to pay, Judge, if we could maybe get a date. That we could come back if necessary, if it's paid, I would assume not come back.
Right, it would be to determine which case to put the court cost onto the back of your back.
Who's going to pay the court cost?
I can pay it.
Okay, so Mr. Mangum will pay the court cost.
And
No, I'll have
two
to-
cases under his name, does it matter which case?
They're both going to be dismissed, so I'd say the 646 is the misdemeanor. 22646. Okay, when can they pay court costs?
Probably like a week.
Okay, well, let's set them out further. Let's go, but she has to come back for a review anyway. So let's do this. Let's set everything for March the 3rd, including her review hearings. And we'll put these on the docket. Mr. Mangum does not have to appear if he's paid the court costs by then. She has to appear anyway because she has his other cases. But her 22643 will be dismissed if court costs are paid on his case.
Thank you, Judge.
Your Honor, may Mr. Morford and I approach briefly?
Yes.
Yes. State of Ohio versus Norman Lucas, case number CRB 22780.
Mr. Smith's case set for pretrial.
There's been an offer made by Mr. Hill that my client's going to reject, so we just need a bench trial date. And
You have a preference?
about a month out, can we do February 3rd? It's a Friday.
You mean March 3rd?
Oh, I'm sorry, March 3rd, yes, a month from today.
Let me check that.
My February's kind of getting filled up pretty quick.
It should be okay. March 3rd at noon?
Yes, sir.
Okay, this case is set for trial March 3rd at 12 p.m.
Is your phone number still the same?
Yeah.
I'll call you, get you in the office.
Oh, yeah, I'll keep my numbers. Perfect.
State of Ohio versus William Joel Myers, case number TRC 222712, A and B.
You're good to go.
Did not check in here.
This is Mr. Smith's case set for pretrial.
It is, Judge. We just got the urine test results today. I was going to ask for a continuance, but I don't know why he's not here.
He's on the screen. What's on?
Oh, is he from Toledo?
Yeah, he's appearing by teleconference.
I think, if I recall right, he's from Toledo.
All right, Mr. Myers, can you hear me?
Yes, I hear you.
All right, so, and did you say that the screening results are not back?
They're back. They were just emailed this morning to Sarah. She gave them to me. I'm going to request time to go with my client. We waive time.
All right. When do you want to come back?
It shouldn't take long, Judge, with the 17th or 24th of February. Either one of those dates will be available.
24th is better.
We could do that, be fine. I will.
All right, Mr. Myers, can you appear the 24th? He can appear by teleconference if he wishes.
Yes, I think he's still in Toledo.
All right, February 24th at the defendant's request is the next hearing. It'll be a free trial at 10 o'clock.
And Mr. Myers, I will call you to go over those results I got this morning, okay?
Yes, thank you.
Okay, thank you.
State of Ohio versus Tad Johnson, case number CRB 16684.
You got it.
All right, Tad Johnson is actually Mr. Stiers' case. Mr. Johnson was at Bethesda.
Push that off.
Okay, so he's been discharged from Bethesda for, well, actually leaving, and he tested dirty. So issue a warrant for him. This is it's a misdemeanor level offense anyway, so he gets a bench warrant for failure to appear today and for leaving treatment.
I will let Mr. Stern know, Your Honor.
Thank you.
Thank you. Thanks for this time. Then I'm going to, I have a meeting I have to go to, and Judge Hall's going to take over for me, so do not leave. He's going to come on immediately. So I'm going to be leaving the bench, and I will come back. I know we got some evidentiary hearings later, so I'll come back probably an hour and a half. So Judge Hall will take over and continue with the docket until I return.
Tell me to text me.
A couple things. Mr. Kratzenberg, what do you recommend? He's good. I don't know what kind of treatment. I don't understand, guys.
Ladies and gentlemen, the Honorable Don Hall will now be presiding in court temporarily.
Assess anyway, just in case he's got some other issues.
State of Ohio versus Zachary Mandelka.
Understanding that.
Case number CRB 21-528, CRA 21-440. Mr. Roger Smith is standing in for Mr. Steyer.
I'm covered for Mr. Steiner, Judge. Sorry, I didn't realize he was up next. I should have. Get your exit. Okay, because we'll have to come back. We did here. It's a pretty involved case. That's fine. Judge, I'm covered for Mr. Steyer. I understand they're about to close his other cases. It's kind of an involved case for me to just do off the cuff today, so I'd like to come back in a couple of weeks if we could. That way he can talk with Mr. Steyer, he's the attorney on the case, is much more knowledgeable than I am. And my client doesn't oppose that, and I don't think the state would. I guess
We don't oppose a continuance, Your Honor, and I think we're getting close to the point where we'll be able to dispose of the case completely, based on what I've been told today. And it involves a children's services case that Mr. Mandelka and the mother of the children have been involved in. So we've been monitoring that.
3 weeks, 30 days, what do you think?
30 days, 28 days, whatever.
That's on 2 files, correct?
That's correct, Your Honor.
You need 30 days, is that right?
It sounds like it, Judge. I'm not real familiar with the case, but it sounds like they're about to wrap it up, so 30 days would be good.
Okay.
I'll waive time on behalf of Mr. Steyer.
Are you going to need an entry, waiving time?
Yes, I will sign that.
30 days would be...
March 3rd is a Friday. That might work, coincidentally.
Today's the 3rd. Well, I don't have March up here. Do you know anything about March 3rd?
I do not know. Schedule you can.
Is that it?
Yes.
Is that good for you, March?
We've got 28 pre-trials on that day. I'd rather do it on March 6th. I'd rather do it on March 6th.
Oh, let me have him check and see. Can do the 6th.
Tuesdays and Fridays are my only days off.
Tuesday and Friday. It needs to be a Friday, Judge. He's off on Tuesdays and Fridays.
It's not switching.
Can we go to the 10th? Or was it the 10th? Is that a Friday? March 10th would be good, if it's available, or better.
The dates virtually mirror the same, February and March.
It's just showing February.
The dates are virtually the same except for the last. I mean, it's exact.
I can't get my schedule to move, so let's make it whenever we want.
March 10th, Judge, be fine. And I'll let Mr. Steyer know that date, and I'll give his client a copy of that date right now.
Somebody bring me an entry and we'll go to the next case.
Yes, sir.
State of Ohio versus Agnes Sexton, case number CRB 22-740 and CRB 2349, A and B.
You're Agnes Sexton. The lawyer's not here. And I talked to the prosecutor. What he's going to do is 2 days jail, suspended on condition of future treatment.
He's here too.
You want to do that?
Yeah, I got assessed last week and then I did a
Bring
group.
your probation, you'll have to complete treatment.
Yeah.
But then they'll suspend all treatment.
30 days of it?
Yep, suspended to.
How long is it? Yeah, I did my first group yesterday. Patty? Yeah, this week I still have one. Well, I did my assessment last week.
30 days suspended. What did you do your assessment last week?
I don't know. There it was. They didn't say anything.
Judge, I think we have a resolution on Ms. Sexton's case. Again, this is one of Mr. Steyer's cases, but I've spoken with his client and spoken with Mr. Hill. I think the recommendation will be 30 days, all suspended, placed on probation, and a specific term of probation be that she complete her current treatment. That's Riverside, right? At Riverside. Make sure I got the right, put you in the right spot.
And we are in agreement with that, Your Honor.
That's on 3 cases, correct?
Pardon?
It's 3 cases.
3? 2.
We've got a resisting and a disorderly, I don't know what else.
Okay.
Domestic violence.
Yeah, the domestic violence was the one.
I have domestic violence 22-740.
2 cases.
I have a resisting 2349A, and I have a disorderly M4 2349B.
Okay.
Does that take care of all these cases?
Yes, Your Honor.
All right.
I don't know if we need a protection order.
I'm sorry, I was trying to
Okay.
figure out something in the other case.
I'll do that right now.
Luke's file, so I can
Agnes,
Yes, sir.
are you entering a voluntary plea of guilty to
Yes.
domestic violence, misdemeanor of the 4th degree, case
Yes.
number 22-740?
Yes.
All right. Are you entering a voluntary plea of guilty to disorderly conduct, misdemeanor of the 4th degree, 2349B?
Yes. Yes, sir.
And 2349A, resisting arrest, misdemeanor of the 2nd degree?
Yes, sir.
All right. Okay, let's proceed to sentencing. Now, what's the agreement?
Judge, as I understand it from Mr. Hill, it'd be 30-day recommendation concurrent, which jail sentence will be suspended and placed on probation with a specific term of probation being that she successfully complete her current treatment, which is at Riverside Recovery. Are you inpatient?
Not outpatient.
How many days credit?
Did you do any jail time?
4 days.
4 days, Judge. We'd ask for hold 26 in abeyance or suspend 26.
Level 3 probation?
Be fine, Judge. Whatever level is appropriate, we don't oppose.
That'd be level 4,
Twice a month?
One's the worst, but I was the easiest.
Level 4 probation? All right. On all 3 of these cases to run concurrently?
Correct.
A plea of guilty. 30 days in the Lawrence County Jail. suspend 26, 4 days credit for time served. 2-year level 4 probation. Agnes continue with her treatment at Riverside.
Okay.
Now, is there anything else that goes along with it, such as
There a
fines?
fine, Your Honor?
Excuse me?
We didn't discuss
Is there
a
a
fine.
fine, Your Honor?
That's what I was just wanting to know.
We
Fines,
did not
costs?
discuss a fine, Your Honor. We don't take any position on fines.
Thank you.
Okay, no fines.
Thank you.
There are court costs and,
Are there court costs on both cases, Your Honor, or were they the same violation date or different?
it's different. So there are 2 court costs and community service involved in this.
We didn't discuss it, so we would not request any.
All right.
Do you want the standard review hearing
Wasn't
date?
court appointed.
We were using.
Was not court appointed.
135 altogether.
Because she's in treatment sooner, I would think.
Let's make it in 60 days, so hold on just a minute.
Yes.
Okay. Okay.
April the 7th, Your Honor?
April the 7th, review date.
April 7th is the review date.
Okay. That's just to make sure that I've completed everything.
Yes.
You said you don't have
Agnes,
So you got a 1 and a 5 tomorrow, right?
That is your next hearing date.
Agnes, wait a minute.
Oh, I'm sorry.
Have you read the report from Riverside?
No.
Okay, take a look at it. And we want you to clear up all the things that do what they're asking you to do, all right?
Yeah, I know I gotta do one group and 2 individuals weekly. All right, 1 individual and 2 groups weekly.
All right. And
For the record, she's looking at the report now, Judge.
clear drug screens.
Okay.
Anything else from Riverside that you wanted to put on the record?
I would just like to say, I mean, she has resumed services this week and everything normally and everything. I don't think that was actually in the report, but she is continuing her services and everything. She had missed, I believe, last week due to her children being ill.
I did the assessment last week, but my kids are home I got 1 in middle school and 1 in high school, and they're all sick this week. So it was good that school was closed Tuesday and Wednesday, but I've had them home all week. But I still managed to go to group yesterday and individual, and I've got 1 more individual this week.
All right. Thank you.
Thank you, Your Honor.
Thank you, Judge.
Well, if you change your mind.
The State of Ohio recalls Philip Kratzenberg, case number CRA 22809. Mr. Cremines, this case.
Brian Cremines is here on behalf of the defendant. The defendant is here, and this is a preliminary hearing.
Your Honor, we have reviewed this matter and determined that it should be resolved here in this court. And we are willing to offer an amendment to an attempted possession of marijuana if Mr. Kratzenberg is willing to plead guilty, and our recommendation would be a 30-day jail sentence suspended. We would ask for him to be assessed for any kind of substance abuse issues that might be present. although there's nothing that we have that indicates anything. I mean, it's marijuana, and it was a sizable amount of marijuana, but we just want to make sure that he's not having any other issues with any other drugs that might need some more substantial intervention. We also would ask for the standard 2-year probation and for him to follow through with any counseling that is recommended. We don't take any position on fines.
Your Honor, based upon that amendment, Mr. Kratzenberg would enter a no contest plea but stipulate to a guilty finding by the court.
Is that correct, Mr. Kratzenberg?
Sir.
Yes?
Yes, Your Honor.
Thank you. The motion to amend is granted. Plea of guilty, or no contest has been entered, and let's proceed to sentencing. What are you recommending?
30 days in the county jail, suspended, an assessment for treatment, and, report have that report submitted to the probation department. 2 years probation. And follow any recommendations of the council. And I don't know what they'll be under the circumstances, but it's important for Mr. Kratzenberg to be truthful about, so they can get to the bottom of any issues that he might be having. We're not suspecting anything other than the marijuana, but we want to make sure.
Are you taking a position on fines and costs?
No, Your Honor.
And community service, are you taking a position on that?
We did not discuss that.
Where does your client work?
Well, I have 2 jobs. I work at UPS in the mornings, deliver for FedEx in the daytime. No, it don't make no sense.
Mr. Cremines, do you have any recommendation as to where he would be assessed?
At this point, not likely, Your Honor. I was going to speak to one of the providers. We may look at maybe Riverside or Lawrence County Recovery, based upon where Mr. Kratzenberg lives.
We may have another 60-day review date.
April the 7th, Your Honor.
Okay. Sentencing is 30 days in Lawrence County Jail, suspended. Any, has he served any time?
He is not, Your Honor.
Thank you. Assessment at Riverside, and Riverside immediately present that assessment to the probation department. 2-year level 4 probation, no fine. Court costs on this case, 60 hours community service. So your next hearing is April 7th, 2023 at 9 o'clock. When you come back, you need, if I were you, I would have that assessment and comply with what Riverside is telling you to do. I would have my community service done, pay the cost, and on April 7th, 2023 at 9 o'clock, we'll be looking good. Thank you.
Thank you, Your Honor.
State of Ohio recalls Kara Summers, case number CRB 2381.
She told me you have an appointment.
Your Honor, this was set for arraignment. Judge Capper wanted her to get an assessment done. She did through Hometown. She has an appointment Monday with them. So I just asked it to be set here in a couple of weeks, allow her to go to her appointment, and then we'll deal with the case then.
Now, Mr. Stratton.
Yes.
That's Mr. Stratton on the record. I can't tell by looking at this file. Are you hired or appointed?
Appointed this morning, Your Honor.
And you're not ready to enter a plea at this time, is that correct?
Correct.
And you're asking to continue the pretrial?
It was set for an arraignment today, Your Honor. We're going to plea of not guilty and asked to be sent for a pretrial in a couple of weeks.
So Judge Capper didn't do the arraignment, or did he?
Well, he did part of it, then he wanted me to go talk to her, and then, so.
All right, let me ask you this. On behalf of your client, then you're waiving anything else with regard to the arraignment?
Correct.
All right. Now, we're going to need a time waiver entry.
We will do that, Your Honor.
For a pretrial. In 2 weeks, did you say?
Yeah, that's fine, Your Honor.
Okay, let's look. Today's the 3rd, that would be.
We'll look at the 13th, maybe, February 13th?
That would be great.
Okay.
There's another matter, Your Honor. We'd like to, we believe that her actual legal name at this time is Hearn.
Yes.
H-E-R-N. We'd ask to amend the complaint to reflect that.
No objection.
How do you spell your last name?
H-E-R-N.
Hearn?
Uh-huh. Yes, sir.
Was it ever Summers?
That is my husband's name, but mine hasn't legally gotten changed.
All right. Motion granted to amend the complaint to Kara D. Hearn, H-E-R-N.
Yes. Thank you, Your Honor.
Thank you.
Thank you.
State of Ohio recalls Chase Lewis, case number CRA 14-1065.
Luke Sire.
Luke Sire's not here today.
Roger representing. Yes. State your name, please.
Chase Lewis.
You got a real good screen there, just like you thought, right?
Yes, sir.
We appreciate that. You don't have any community service to do, but you do owe $963.82.
Yes, sir.
And it's been a while since you paid anything, right?
I paid last month. Yeah, my last court date want to say it was January 3rd.
Right,
Yes, sir.
okay. When are you gonna pay some more to knock that down?
Today,
How much you gonna pay?
$30.
All right. Okay. We're gonna need a 30-day review, so that would be March the 3rd.
Oh.
2023 at 9 o'clock.
Thank you, Your Honor.
Thank you. And continue with those perfect screens. That's so important, okay?
Yes, sir.
Thank you.
Thank you.
Thank you.
State of Ohio versus Don Williford, case number TRD 213491, A and B.
Withdraw the bench warrant, please.
Thank you. I'm with my treatment provider. They're with me. They brought me this morning.
Oh, good. Who's here? Who's with you? Come on up. And state your name, please.
Dawn Marie Williford.
Tanya Cantrell.
Okay. And this is inpatient?
It's outpatient, but she lives in a sober living housing unit with us.
So are you taking her to and from court whenever she needs to be?
Yes.
That's great. Now, this report is dated today, and as I read it, it looks like this is what's going to happen. What's happening before today?
It's what's continuing. Those are the services that she will continue to get, 5 groups, 1 to 2 counseling sessions. She meets with peer supporters. She meets with a case manager on a daily basis. Just kind of a rundown of the services that she is receiving currently.
And she's living in one of your...
Sober living houses, yes, sir.
Okay. Are you working?
Yes, sir, I am.
Where?
I work for IHOP in Ashland.
What do they do there?
IHOP, International House of Pancakes. I'm a server.
What do they do there? I didn't understand the nickname.
Okay, I'm sorry.
That's all right. I've had many a pancake there.
And you've never called it IHOP before? IHOP, it says it right on the sign.
It's probably more commonly known as that, but I just didn't get it. Well, everything looks good.
Thank you. And I'm making a payment today, and I do apologize for being late. We were under the impression that we were supposed to be here at 10, but now I know it's 9, so I will be on time.
Okay.
For future reference.
And you're not driving, are you?
Yes, I have a valid driver's license. They've worked with me, took me back and forth to the BMV. I've been working on a lot of things while I've been there.
Now, wait just a minute. So you've taken care of your driving under suspension?
Mm-hmm.
Okay. So you have a valid license?
Yes,
right
sir.
now? All right. Is that an Ohio license?
Yes, sir.
Okay. Well, how long ago did you get your license straightened out?
What? It's been a week.
How long?
A week.
Okay, it was December 2021, and the OVI suspension has elapsed, right? Okay. Well,
And I completed the driving course that I was asked to complete. I did a 3-day at Spectrum. I did that course as well.
well, you know what? That is great. And that shows me right there that you're diligent because you're dealing with the Ohio Bureau of Motor Vehicles.
Amen.
Now, I want you to do something for me.
Yes, sir.
Well, okay, everything's good. You're going to continue with what you're doing at Lawrence County Recovery. I'm going to set this for another hearing.
Okay.
On March 3rd, 2023, for a review.
Yes, sir.
Now, did you say you helped her get her license back?
Yes, my case manager in the household did help her navigate the BMV in order to do what she needed to do to obtain her driver's license.
Okay, do you have something from the BMV that says she has a valid license?
I do not have anything with me, do you, Dawn?
I'm looking. I didn't think to. I don't think I thought to bring it.
You have your license?
I have my license with me.
That's not going to help. All right, here's what we're going to do. You're set for March 3rd, 2023 at 9 a.m. Now, I want you to go out the door, turn right, and see Clarissa.
Clarissa?
And ask her to run your name to see if your license is valid.
Okay.
And that'll, because you don't want to drive if it's not.
No, because I've done everything. I spent so much time at the B&B, I should get a bed there.
Well, you know what? I really believe you.
Right.
But you have one of the hardest things to deal with, and I want to make sure you have a valid license. She'll check it for you.
Okay.
And if you do, you can leave, no problem. If you don't, I want you to come back in.
Yes, sir.
Thank you.
And I'm going to make a payment while I'm there.
Good. How much is that?
I'm going to make a $20 payment today, and then they've been helping me get a budget plan going so that I can start paying all my fines regularly.
Okay, now, how often do you work at the Pancake?
I work 5 days a week.
All right. Now, I don't know if Judge Kapler told you this, but Josh provides a program in community service which will get you, tell her how it works, if she works it off.
$50 a day for a 6-hour day.
Okay.
But I know you're busy, but he works on Saturdays too. And his work's going to pick up when the weather gets better, and it's getting better. So you can use that to knock this thing out.
Okay.
And really, you're almost finished.
Yes, sir.
You're doing good.
Thank you.
Thank you. I hope you have a valid driver's license.
You better be. Thank you, sir.
You're welcome. Thank you.
State of Ohio versus Justin Casey, case number TRC 222460 A and B.
This is Attorney Sean Stratton's case, and he has Mr. Casey here, and I have a report from Spectrum. Let's see.
Do you have a copy of this letter?
Yes.
Does it? Yeah, okay.
And what is your name, ma'am?
Maddie.
Maddie, what's your last name?
Minter.
Spell that.
Minter.
It's a second, yes it is. I know.
What do you do at Spectrum?
I work in the office in Ironton, a counselor and an office manager.
And you brought us this report today, right?
Yes.
Go ahead. Okay, it doesn't matter.
Mr. Stratton, this may be one of the best reports I've ever read.
It is, it's very good.
I'm sure maybe that you wrote this. Did you write it? I mean,
Not quite,
it's near perfect,
yes.
and I want to commend you for that, Mr. Casey.
Thanks, sir.
Look what you've done with your life with the help of Spectrum.
Yes, sir, they've been good to me. They've helped me turn my life completely around.
Now, it's mainly up to you, isn't it?
Yes, sir.
Look how good this report is. Everybody should have one like this. You've done everything right. Now, where are we on the pretrial?
Your Honor, I think we'll be able to resolve this, but we'll set it for another pretrial. I think the judge wants to just keep track of it, make sure he does well, and then it's whatever we decide to do with it depends on how he does at Spectrum. So.
All right, and how much time do you need?
Well, we'll probably set it a month out.
Okay, I'm going to keep setting these on March 3rd until Dorothy tells me not to. March 3rd.
Yeah, that's fine, Your Honor.
2023.
Can't calculate, I'm sorry, I can't tell how many cases we
I
have.
know. Can't get it to move.
I mean, I can't tell from longer. You can set them all day long.
So March
You're not going to ever tell me this
I'm
one?
not gonna never, I'm not ever gonna tell you. Just don't set them on March the 10th, we have a possible jury trial.
Don't put it on the 10th.
On the 10th, I'll.
March 3rd is fine.
March 3rd, 2023 at 10 p.m. for a pretrial. And
Thank you, Your Honor.
continue with the great work that you're doing there at Spectrum. It's just so good.
Thank you, sir.
Hey, Sean.
The young lady's license is back.
Great.
We don't.
Hey, come on.
Maybe it's just a call.
Maybe give her a copy of that.
John,
Something is okay.
I think it's okay. He doesn't really work.
State of Ohio versus Kara Walasick.
There's no more big.
Case number TRC 222589 A and B, TRD 2328.
You're helping.
There's two different attorneys on these cases, Your Honor. Mr. Schreck was appointed back in 2022, and Mr. Steiner was appointed on the 23 case. And so I'm not sure what the mix-up is.
Well, two are better than one.
And then you have a third one stepping in for Luke, so it's really, she's got the dream team.
So,
Okay, let's see where we are.
so the judge wanted her to seek some counseling. So she has an appointment today at One Stop Family Medical Center. So we just need to set it for another date and see how that goes.
Okay, so what we have the DUS driving under OVI suspension. You're not driving, are you? Okay. You'll end up in jail if you do. Not a good thing.
I think we could set it for that March 3rd date.
It's probably administrative license suspension.
Okay, now, I've been handed a report from Spectrum.
She's going to One Stop now, Your Honor. She has an appointment today at 1, so.
Let me write that down.
Yeah, don't worry, just go where you're supposed to.
Okay, let's see.
Since it's a carryout.
Yeah.
You get your lottery tickets there, you get your cigarettes.
Yeah, see, that's a big day.
Okay, here's what we have. We have an OVI and marked lanes, and we have a driving under an OVI suspension. That's the two files we have today. And Luke Sire represents you on the second one, and Mr. Stratton represents you on the OVI. What are we going to do today?
Your Honor, she has an appointment today at One Stop Family Medical for treatment. She's already assessed. Yeah, she's already been assessed. It's her appointment. I think we should just set it out a few weeks and see how she does, and then we'll resolve the matter after that.
And is her appointment with Spectrum?
No, One Stop Family Medical Center. It's in Ironton. Right, yeah. What about Riverside?
Well, that's where she recommended. It's right by her house. Riverside's right directly by her house.
Okay.
Who is that talking?
I'm not sure who that is.
I'm sorry, I'm just.
Luke's other one.
She lives right beside Riverside, and the other place is all the way in Ironton. It would be easier for her to get to Riverside.
Well, you know what? She's got two lawyers and one somewhere else, so let's hear what they have to say.
I apologize.
What do you want to do? You want to?
Why not Spectrum? What, was there a problem with Spectrum?
Whenever I got my assessment, that's where they made the appointment to One Stop, I guess. I got it all in Ironton, and then they just told me to come back for the appointment. And I got my, the last time I came to court, they told me to get the assessment, and I talked to the lady here and scheduled it, and then went and got it.
Translate what she's saying.
Right
I'm not sure I understand.
They've just recommended the agencies to her irrespective of the fact that she lives right next door to Riverside or whatever. We want her to stick with one place, for sure. Another thing, Your Honor, if it's my turn to speak, if I may, this case has been pending for quite some time, and we've hardly had any discussion about how we're going to resolve it. So we either need to have a trial soon or have her plead. If she were to plead, we would agree to delaying the sentencing, allow her to do her treatment, and then we would be able to make a recommendation to the court in keeping with her success in treatment. In other words, the better she does in treatment and the better she is at maintaining her sobriety, the better offer we would be able to recommend to the court as a resolution to the case. Right now, the mandatory minimum is 10 days in jail. And the maximum is 6 months in jail.
Your Honor, I think we're going to resolve this cases, but let's get her established in a place first. That's the first step.
It's really not the first step as far as we're concerned. First step is guilt or not guilt. But we're happy that she's in treatment. We want her to do well, so I don't want her to get the wrong message in that respect. It's going to help her, in our minds, if she's successful in treatment.
Spectrum has something to say here, but you know what? What Mr. Heald is saying is so true. I don't know you, and I've never had your case, but I can look at these files and tell you have a serious problem. You've got a prior OVI, you've got this OVI, and you've got driving while under an OVI suspension. And we can't seem to figure out who's going to take care of your problem.
Well, she had her assessment on the 4th, then we told her to come back the 6th, which would have been that Friday, and she never returned. So we wouldn't tell her to go to One Stop if she's with us. So she just never came back after her appointment on the 4th to come back on the 6th.
I thought that was what I had today, because I got a voicemail yesterday, confirming my appointment for today. I didn't sign up for One Stop or anything. They called me. I thought it was that.
Okay.
Yeah, and I've seen that voicemail, so I can see where she's assumed that. That's.
Let me ask Sean Stratton something.
Well, it transcribes it.
What, in your opinion, who should she see to help her with her problem? Who do you want, I want to put it in
Where do you want
the
to go?
If it's in Ironton, then I'll have to do the telehealth, but if it's in Riverside, then I can like go in person.
Let's do Riverside.
Okay. Is that, we're going to go, this is the third one, I'm going to take off that one.
I wonder if there's a representative from Riverside here.
Riverside does have a representative here, Your Honor.
So maybe she could be assessed.
Come on up. Come on up, please.
You'll talk to that guy right there. Okay?
State your name, please.
Yeah, my name's Aaron Sowards. I'm the intake coordinator for Riverside.
So she could talk to him after we get a new date, and we'll make some decisions on the case at the next pretrial.
All right.
This case has been before the court since November, so we want a trial date for next time unless, I mean, we've given a lot of time to allow for planning as to how the defense wants to proceed.
Well, I really don't want to do anything today without Mr. Steyer being here. Mr. Smith is just standing in for him, so to force a plea on the client today without one of her two attorneys here, I think is inappropriate.
Okay, so what we want to do is ask for another pretrial in the near future.
Yes,
So that
that's
decision
fine.
can be made at that time.
All right, I need an entry, waiving time, Sarah. And look, you need to focus on your problem.
Yeah.
Look,
I got a job and I work Monday like through Thursday, 10.5-hour shift, so I'm not, like, I stay home and I go to work. I'm not doing any, like, I'm not out driving, I'm not.
so do you understand that alcohol is a huge problem for you? I mean, if you've got 2 OBIs, you've got a problem with alcohol. Plus, you're driving with an OBI suspension. Now, you've heard all of this, Mr. Sellers. You're going to jump all over it, right?
Yeah, we're gonna work with her.
All right. Pre-trial set for March 3rd, 2023. Assessment at Riverside. And at that point, Judge Capper will set a trial date.
Yes, I understand that. Okay, talk to this guy. Thanks, sir.
State of Ohio versus Austin Hawthorne, case number CRA 2357, CRB 2358, CRB 2893, or 843, CRB 20, PRC 191305, A and B, CRB 19393. Austin Hawthorne is not checked in, Your Honor.
And one more for this representative, Mr. Hawthorne.
Your Honor, we will nolly this to the grand jury.
Let the record show that Mr. Morford is here, but his client is not. And we have a felony of the 4th degree, and the rest of these are probation. That the state is going to nolly to the grand jury. Anything you want to say, Mr. Morford?
Judge, I haven't seen my client since we were here last at court, excuse me. Haven't heard any telephone calls. No contact.
All right. And Josh, I want you to report that to John Major. He's got all his, show up for any of these hearings. And if John wants me to, I'll issue a bench warrant for the failure to appear. He's going to take care of those. All right? Let me know.
Are you going to issue a warrant, Your Honor, or?
Excuse me?
Are you going to issue a bench warrant for him?
Well,
No, we just nolly everything to the grand jury.
You have review hearings, right?
You got a bunch of other stuff too.
Yes.
yeah, you know what, I want to do that. Just give me the files back. Failure to appear on each of these cases for bench warrant, that is Austin Hawthorne. And Ron James has told me on the record that he has not appeared today. Is that correct?
That's correct.
Failure to appear, bench warrant, on the 3 probation cases.
Thank you, Your Honor.
Thank you. I don't see the. Oh, he's already got finished
So those was, his last bench warrant was recalled 124, 22.
124-22.
That's what the computer showed was at the bench warrant.
So he, 120-23, he was arrested.
I'm sorry, that's the wrong case.
I'm going to go with just this one then, because that's the only one I can see.
January 20th was the last bench warrant.
And a bench warrant.
2843 was recalled January 2nd.
Failure to appear. There's so many notations on this file, I can't find the last one. Oh, that's what it is. So on this one today, failure to appear, bench warrant. And I can't, you can find this.
Your Honor, Attorney Tyler Smith has asked that we call the Darrell Road case up. She is in jail, but she does not need to appear today according to him, and he has something to put forward.
Okay. Tell Philip Heald that, okay? We're going to need to, do you know what he said?
He's gonna message me back, I'm not sure.
Darrell Road.
Do we have the file?
I don't know why. It's
State of Ohio versus Darrell Road.
it's an extra.
Yeah. Tyler Smith is here representing her, and is the only thing we have here today the issue of the extradition?
Yes, Your Honor, and I represent her in Common Police Court as well in some other felony cases. And she pled this past Wednesday, and we have a sentencing hearing on her plea February 22nd. So I've presented a motion to continue with a waiver, time waiver until the 24th. Come back and address that extradition at that time. She's going to be sentenced to prison. Just don't know how long she'll be sentenced to prison for. So.
Okay. Mr. Heald.
We're not opposed to that, Your Honor.
All right. We'll grant that, and on the 24th, Mr. Smith, be sure and I guess you'll be asking for this case to be dismissed until she gets out of prison.
Well, on the extradition, they'll probably just keep a hold on her until she finishes her sentence in this case, and then effectively pick her up at that point. So.
2/24/23.
Yes, Your Honor.
At 10 a.m.
Thank you.
Thank you.
State of Ohio recalls Austin Hawthorne.
Excellent.
Your Honor, if I may, I talked to Andy Davis, and Mr. Hawthorne is inpatient at TCC and
So why wasn't he here?
he didn't give me a reason. Mr. Davis didn't give me a reason why he was not here.
That
But he is
changed.
inpatient, doing good, and they are going to send us a report.
Well, I'm glad you found that out. How did that come, what made you think of that?
The last time he was here, they talked about putting an ankle monitor on him, and I just remember.
All right, does that change your approach, Mr. Hield?
I did call and verify that he is inpatient.
He's not here, and it wasn't his fault, apparently.
Well, yeah.
Someone should have brought him here.
If we can undo what was already done,
We can, because I haven't signed anything yet. Have I?
okay then.
Yes, Your Honor.
I did?
I mean, no, I don't know where the injuries are, but I can undo them.
Okay, we can. What do you want to do? You're not going to nolly it to the grand jury, right?
No, I don't suppose so. We wanted to be successful, and so, but now I will tell the court that we discussed the fact that he was on a very short leash, so he's going to have to really comply and make some progress in the counseling center, which we hope that he does.
Okay, let me write this down. Mr. Hawthorne, where is he?
He is inpatient at TCC, the counseling center.
All right. Now, Mr. Morford, that changes everything for you.
Judge, maybe would you reset this for a week, then I can get in touch with TCC, and if they don't transport him, we have him available by Blue Jeans.
That would be a preliminary hearing, right?
Yes, Your Honor, and review on the older matters.
We can't set it on February 10th, so make it,
No, that's March the 10th, what we can set cases on.
so I can set February 10th?
Yes.
2/10/23 at 10 o'clock. Thank you.
Thank you, Your Honor.
Judge Capper has returned. He will be back on the bench.
Butch. Hey, Butch, are you going to have your guy brought here for the preliminary? You're going to have your guy brought here for this preliminary hearing?
Wouldn't hurt anything.
No, but you ought to go ahead and maybe try to get that done.
Court is now back in session with Judge Capper presiding.
Well, I'm going to tell the judge.
State of Ohio versus Anthony Jones, case number CRB 20-490, PRC 18-875, and TRD 20-2242 A and B. You did not check in, Your Honor.
All right.
We were informed this morning that he had cut off his ankle monitor and left the facility.
Seems to me like he
That's 3 years
was going to star or something.
Unfortunately, we were informed this morning, Your Honor, I don't have a report, but Mr. Jones left our facility this morning and cut off his ankle monitor. We informed adult probation.
I think he had a case of common pleas too, right?
Yes, Judge, he was there February 1st. He was supposed to complete residential on that date and goes back to common plea. Well, he actually has a trial set, Your Honor, in April on the common pleas charges.
Well, looks like once they catch him, he'll be going to prison.
3 years on that alone.
So you all, I don't know if any of you will ever get an ankle monitor, but if you do and you cut it off, it's automatic 3 years in prison, is my understanding. That's not up to me, that's up to the common pleas.
Pretty much a universal rule, Judge.
All right, well, we'll issue a warrant for Mr. Jones from this court.
Thank you, Your Honor.
For failure to appear.
Thank you, Judge.
You're welcome.
State of Ohio versus Cody M. Pritchard, case number CRB 22-721.
Mr. Pritchard is here with his father and Mr. Morford's counsel.
You in your house? How's it going?
Need to shave my haircut. That's happening as soon as we leave.
Yeah, he's gotten a little fuzzier since he was here last.
Said it keeps him warm.
Yeah,
it does. Yes, sir.
You can grow a better beard than
Is that
that.
Leo Gibbs here?
Yes.
Up here.
Can you come up?
I didn't know.
He is in his own home now, Judge.
Been there since November
Yeah, I remember the last year he just had moved in there and was doing well.
Been great, got a job at Powell's, gets paid today, he's buying me lunch.
Okay, good.
I need lunch too.
I know, yeah.
Cases like this, primary concerns, making sure that, somebody like yourself doesn't have any other problems with him. I think that we had to dismiss the other cases.
Because he can't find me.
Is he coming? Huh? Yeah, let me have your father. I'll have you sign it.
You know, you got to go until she's here. Okay.
He's still doing that?
Yes.
May we approach, Your Honor?
Yes. It's really nice. It's really nice.
Okay, so I read it. I didn't bring my book.
Take a break. I'm ready.
They wouldn't to drop this if you would agree to do 30 hours of community service.
What that means?
You come
and you work for this gentleman right
Judge
here.
Cooper will give you work assignments.
What?
Mr. Cooper, you come in and he'll give you work assignments and you work 30 hours for the court.
Okay.
Yes.
We're in agreement, Judge.
Okay. Well, let's, want to put it off for a couple months then, to let him get that done, and then we'll come back.
Please.
See where we are then.
Yes, sir.
My understanding, it's Ms. Gibbs, is that right?
Yes.
You're agreeable with this, ma'am?
Yes.
Okay. Anything else you want to tell me about it?
About what?
About the case?
Oh, no, just.
I just wanted to give you a chance to give input if you wanted to.
No, it's kind of, it's not the first time, and
I understand.
I've worked almost 8 years in the same field. It's just, community service just gives some type of, there is some consequence, you just can't, but not like charges or anything. There is some, you just can't do anything you want whenever you want to.
I understand. Okay, so I think we're at a meeting of the minds on that. So let's make it, if you're available, Mr. Morford, 2 months will be April 3rd.
I'm good then, Judge, I'm pretty sure.
And that defendant waives time, be
Wait.
dismissed then if the community service is completed. And there's no further problems, that's a caveat. And ma'am, you're welcome to be here for the hearing if you want, you're not required to be, it's up to you. Okay, April 3rd, 10 o'clock for a pre-trial.
Hey, Judge.
Thank you. Say thank you.
Thank you, Judge.
You're welcome.
What would they do again with him?
We gotta work with Mr. Cooper.
Yeah.
Do some stuff for the community.
What that means?
We'll talk.
He'll tell you.
Josh will meet with you just.
Thank you, sir.
Just wait right here and he'll come and meet with you.
State of Ohio versus Philip Thacker, case number CRB 22508. Philip Thacker.
Okay, this was Mr. Morford's case too. My notes on it were, it would be dismissed if the defendant, if there was no further problems and the defendant paid the court costs. And he didn't have to appear today. I don't see the court costs have been paid, and I don't see that he has appeared.
He hasn't appeared.
Any,
The computer is set for February the 10th.
okay, you're right.
Well, I didn't have a file, that's why I sat down, Judge.
Yeah, it's mistakenly got put on today's docket. It should be next, yeah, that's next Friday. All right, I'll pass it till February 10th.
Thank you, Your Honor.
You're welcome.
Can you do that?
State of Ohio versus Kerry Wheeler, case number CRA 22776, CRA 22765, A and B.
All right, this is Mr. Morford's case, and Mr. Wheeler is here.
Did you do the assessment?
Yes, I did.
What did they recommend? Inpatient, outpatient?
Outpatient.
My approach, Your Honor? Yes.
These are the results of my assessment.
Okay.
And the recommendations and screen there also.
Thank you.
She needs to come today to sign a treatment plan. It's recommended 3 outpatients and 1 individual. She needs to come in and sign a treatment plan.
Where's Mr. Wheeler living now? Where are you living now?
I'm not at home. I'm stayed in a hotel, stayed with friends. I'm just not able to return home because of the protection order.
Mr. Hill?
Your Honor, I've had the pleasure of being able to be in contact with Mr. Wheeler on several occasions since this case started. And there have been times when he said, please don't have her come back. Please get along better without her. Then there are other times when he says it's okay for her to come back. And I don't have a current opinion from him that that I could advise the court of today. But we want Ms. Wheeler to maintain some consistency in her treatment so that she doesn't have another problem when she does go back.
And she was at the counseling center inpatient. I think she left there.
She just...
You went to SOMC, didn't you? And then they sent you to Cincinnati?
Yes, correct.
And she left, okay, so she left the hospital in Cincinnati afterwards.
Were you discharged or did you waive AMA?
I was discharged.
Okay.
Yeah, I mean, I completed it, but
At the hospital? Did you leave, were you discharged or did you leave against medical advice?
no, I didn't leave against medical advice.
Okay. She did not leave the hospital AMA, Judge.
Well, what's the state's feeling position on going forward with the way things are now?
Well, she's at, is this Southern Home?
Yes, sir.
So that's where she's at, and we want her to stick with that. And I don't have an opposition, Your Honor, if we had another hearing in a short period of time for me to be able to consult with Mr. Wheeler again. It would be, I think, impossible for him, if not impossible, very difficult for him to get here. But I'm able to speak with him to find out what his current feeling is about Ms. Wheeler going back home. But the one misgiving I have about that is that it seems like it's not long until they have more problems. And then we'd have more charges.
That's been the history. I can say that.
You need to know about pace.
Yeah, as long as I'm not drinking, I don't have any problems.
Okay, well then don't drink.
Oh, exactly.
Very simple.
I've been sober since the 6th of December.
All this will go away.
Yes,
if you
sir.
don't drink.
Yes, sir.
And you need to have Southern Hope and sign the treaty.
How about the 13th is the next hearing? February 13th.
Let me check, Judge, because I've got a trial starting right in there. I'm here then.
And that's sufficient time for you, Mr. Hume?
Yes, Your Honor.
Okay. Next hearing will be February 13th. Ms. Wheeler, you're to continue with your counseling at Southern Hope and comply with what they've set out for you.
Yes, sir. Thank you.
Thank you, Your Honor.
You're welcome.
Okay, thank you.
Keep on.
Okay.
Thank you, Your Honor.
State of Ohio versus Richard A. Knapp II, case number CRB 2364. Richard A. Knapp II. Did not check in, Your Honor.
Did not have counsel at the range. Pre-trial was set for today.
Your Honor, there's a cross-filing. Tory Lynn.
State of Ohio versus Tory A. Lynn, case number CRB 2363. Did not check in.
Same. They had both signed signature bonds at the arraignment, were ordered to appear today at 10 a.m. So after that, they haven't appeared. The warrants issued for failure to appear.
Your Honor, Ms. Lynn appears to be from Lynn, Massachusetts. At least that's the information we have. Or we've got an address for her. And we also have an address for Mr. Knapp, that he's living in Lynn, Massachusetts. And they're married. And they informed our office that they just wanted to go home to Massachusetts. So I don't know whether they're still in this vicinity or whether they've taken off.
There was a Chesapeake address listed on the charges.
Yes, so we may never see him again, but.
If they stay in Massachusetts, there's a good chance of that.
And I wonder, if her name's Lynn and they live in Lynn, Massachusetts, her family must go way back. Probably colonial days.
So you do want the warrant issue?
Well, I think, sometimes I hate making snap decisions. Well, yes. Yes, maybe that'll help them to stay in Lynn, Massachusetts.
Well, we stay out of Ohio. Okay, be a warrant issue for failure to appear.
State of Ohio versus Dylan Hayden, case number CRA 22473, PRC 222096, A and D.
Mr. Morphin's case set for full hearing.
Lots of stuff. Yeah, he's at OVP, or at least he was. He was. So see where he is now. He's at OVP. This is my, where I went to OVP this morning to the drug screen. Got there on my counseling. Do you have a report? No. Okay. So it's a court.
Judge, do you have a report from OVP?
I do, but it's dated January 16th, so I don't have one since then.
I've got results of a test taken today, February 3rd, and he's negative for all substances tested.
Are you good? Oh, yeah. Yeah. It's the only way, this is the only way.
Well, this is a very old case. We need to get to brass tacks on the OBI. What are we going to do on that?
Well, he pled guilty to that back on August the 8th.
Okay.
It's a first offense.
Well, let's go ahead and do the sentencing then. There was a time period where he was out of pocket.
Yes, sir.
And he's still got the possession pending.
Okay. What were the results of the urine screen that were done? The one that was done at the time of the offense.
Can you, Josh, can you take that up to the judge?
Okay. Some pretty dangerous stuff. Well, what I think we should do, what I'd be willing to do, I'm going to go ahead and sentence on the OBI, keep the possession pending while he continues to go to treatment. If he's successful, then I assume the state is still willing to dismiss that.
Yes, Your Honor.
All right, Mr. Morford, anything you wish to say or your client wishes to say before sentencing on the OBI?
Judge, obviously, he has a drug problem. And I can't imagine trying to drive with all these substances in my system. However, he is, I believe now, taking his counseling seriously, had a negative drug screen this morning, and says he's compliant with treatment at OVP.
Okay. Anything you wish to say, Mr. Hyde?
No.
Okay, on the OBI, I'm going to impose a $500 fine. Order you to pay the court costs. There'll be a 6-month license suspension, which starts today.
Could I get some driving privileges just for work?
Yes, sir.
That'd be it. I'd be happy with that.
I'm going to order you to do community service, 5 days of community service on the court's community service program.
Okay.
You'll serve 2 years of probation with monitoring from the probation department or court. I will suspend the driver intervention program if you agree, if you complete OVP, because that's going to be a lot more intensive than you going to a 3-day school. Because I'm supposed to make you go to the 3-day school in addition.
Right.
I'll waive that, and I don't think the state's objecting to it. But I gotta have a letter of completion from OVP.
Absolutely.
And you, according to what they said, you just got started January 5th, so you've got a ways to go.
You do.
It's a little bit disappointing. OVP was one of our, I would say, first trusted providers when they started, and were really good about giving us updates. That is not happening so much now, but I know you get quality services there if you will go and do what they tell you. It is medically based. It's people that know what they're doing. It's not a fly-by-night organization, but they're not doing very well as far as updating the court on treatment. So I want to kind of put that in your...
I'll start bringing a paper every time.
With you on your letterhead when you come back to court for your review hearings.
Absolutely.
And I have a contact there. I will try to spur on to do better on their reporting. I will give you a permit for work to come to community service.
When can I start doing that community service? ASAP?
Tomorrow. Tomorrow will be the first day you can do it.
Cool.
It's every day, but Sundays or a holiday, you can do community service any of those days.
Okay.
And Mr. Cooper is here in the courtroom, is over the community service, you can talk to him about it. And then you're going to talk to Mr. Major about your probation.
Okay.
The main thing is I want you to get clean and stay clean. And this is a great opportunity for you to do it. You're going to have a little accountability to me, but really, it's got to come from within you. I mean, I can stand over you and try to get you to do as much as I can. Believe me, I've got hundreds, if not more than hundreds of people I've done this, so I know. At some point, it has to come from within you, because I can't be there 24/7. To say, no, Dylan, you can't do that. No, Dylan, you can't hang out with those people. You got to find it in here to change. Whatever it was that caused you to get where you were before, you got to change some stuff to stay clean.
I've worked really hard at that, honestly. I have. I've changed the group of people I've hung around.
That's exactly the right word I was using. It is work. And you need to keep working, and it's going to be
successful.
A lifetime of work, really. I mean, we all have to work at things. This is going to be one of the things you have to work at.
Right.
And once you have this as an issue, it's something you have to be on guard. We all have to be on guard for it, but you especially are going to have to be on guard about this. And there's no reason you can't be successful. We have people successful all the time. You can do this, but you have to dedicate yourself to it, and you have to want to do it. Those are the two main things.
That's it.
It has to come within you. I'm going to give you a little extraneous motivation, but at some point, down the road, it's got to come from within you, because I'm not going to keep you here forever.
Right.
So you're at a good place. Take advantage. What you're getting from OVP is worth thousands and thousands of dollars if you will use it. Okay. On the parking in the fire lane, I'll give you a $20 fine on that. And then the possession of heroin is still pending, but if all things go right, that's going to get dismissed, but that's up to you.
Awesome.
And that's really important, because this is the most serious charge of all the ones you've got. This is a felony, but you're getting an opportunity to make it go away. I mean, that's huge.
That's
because a felony on your record is bad stuff.
Yes, sir.
You don't want that. So it just takes you doing what you're supposed to do, and it will go away. Okay?
Thank
Got
you.
it? I want you to go meet with Mr. Major about your probation, and let's see, we need to set a review hearing. Let's make it March the 10th, so a little over a month. Come back, and I want to see a report from OVP.
Okay.
And I'm going to text my contact there right now and send them a copy of your information. So they got your social and date of birth. You can get it. Okay. Okay. Any questions, sir?
Yes, sir.
Okay. Good luck.
Thanks, man.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Cedric Leggett, case number CRA 22-722.
Was everything taken care of? Whatever county you're in? Yeah, I told her I'm going to do this and I'm going to do one county is in and I'm actually going to back up after the next.
Okay, the note that I have, this is one where it's Carter County, Kentucky, and they've withdrawn their warrant, if I say.
That's our information, Your Honor.
Okay. And I think that's the only thing I still have here. There may be something in common pleas here.
Yes, Your Honor.
Okay.
Mr. Starr. I'm sorry.
We can
Mr. Starr,
dismiss
please.
the extradition because the warrant's been withdrawn from Kentucky. So, case here is dismissed, and you'll need to take care of whatever he has in our common police court.
Thank you, Judge.
You're welcome.
You're done. When I gotta go back? No, not here. Just come please to the court not to. Yeah, you will get like a note or something. No, I'm gonna. You should know when to go. They don't call anybody. Huh? They don't call anybody. You need to go. Oh, wait.
State of Ohio versus Ryan Jeffers, case number CRA 23-73.
This is Mr. Morford's case, preliminary hearing.
Oh, yes.
Okay, so this is set for a preliminary hearing today.
Your Honor, our office was in contact with the authorities, administration at the Southfield High School, in particular Mr. Graham, the principal. And it was determined that it would be a good idea for me to speak with Mr. Graham personally to decide exactly where we need to go with this case. One of the things that has not been filed is a criminal damaging charge. And we are going to hold that for the time, you haven't filed that yet. We're going to hold that until we figure out exactly what we need to actually do in the case. Right now, we've got a felony charge that we could take to the grand jury, but we're still making that determination whether that is the best thing to do or not. So if I had a chance today to call him, I would, but it's hard for me to find enough time during court to do that. So if we move the case again, even to Monday, I don't even know if that's enough time, given that it's the weekend, we would be able to make a decision what we want to do. I don't want to just make a knee-jerk decision to take it to the grand jury without considering the input of the people that are most important as far as being victims and witnesses to this.
Mr. Moore?
Judge, I don't have a problem with a short continuance. Mr. Hill, I would ask you to ask the powers that be down there the exact words my client used, because I don't believe they're what's alleged in the narrative or the affidavit.
Okay, do you want to come back Monday, or is he suspended from school, or what's going on with the?
He is suspended, has an expulsion hearing scheduled for February 8th.
Okay.
So I would suggest, and he goes to college? Is it right?
Yes.
I would suggest a week from today then.
The 10th, because that hearing will have occurred by then, so. All right, at defendant's request and with a time waiver, we'll continue this for a week to February the 10th for another hearing, preliminary hearing, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jessica Johnson, case number CRA 22-156, CRA 22-157, CRA 22-545.
Okay, Ms. Johnson is appearing by teleconference.
Yes, she should, yes.
Here, and Mr. Smith is the attorney.
Correct, Judge. Excuse me, I had sent a text with her most recent report from the Savannah Mission where she is conducting her treatment.
You sent a text?
Yes, Judge. It appears to be in order. I'll also copy it to Mr. Heald as well. It's a rather brief summary.
Mr. Hill?
Well, Your Honor, it appears she's still in the program and immersed in the program, apparently as a resident there, and going through what appears to be a heavily faith-based approach to rehabilitation. It's in Savannah, Georgia, I guess, so it's not as if we have the ability to go there and see, but it appears to be an established program. And I don't know what her plans are if and when she completes the program, but I guess that would have an impact too on what we would feel about it. If she plans to come back to this area after she's completed the program, then I guess we would want her to check into the court and see if she needs any further services from a local agency.
Yeah, I agree, Judge. It looks like a good report. Jessica, when do you anticipate program completion?
My program completion will be July 21st.
Oh, till the summer, okay.
Yes, sir.
Judge, I would suggest then that we come back, however long Your Honor thinks is necessary to just monitor, make sure she stays compliant.
Well, the thing that's troubling about this is that she was in a different program locally. She left and she was out of pocket for several months. And then she took it upon herself to pick this program, which I know nothing about. and it's just a program that you pick. And it's, she's there, she's not here. I reserve the right to make her appear after she leaves this program in this court, and we'll make an assessment then as to how we should go forward. So generally, you don't get to pick where you go to treatment. Okay, so we'll just keep monitoring you while you're there, and then it's my understanding you're a Huntington resident. Is that your plan to come back to Huntington once you've completed?
Yes, sir.
Okay. Well, you can plan on coming back and appearing in this court once you've completed the program. That's going to be required.
Absolutely, sir.
Okay, I'm looking in March, Mr. Smith. What do you have?
The 3rd or 10th, or Fridays?
Let's do March 10th.
Okay.
Your next hearing, ma'am, will be March the 10th.
Okay,
10
thank you,
o'clock.
Your Honor.
You're welcome.
State of Ohio versus Scott Taylor, case number TRC 222629.
Okay. It's on the trial docket.
Yes, sir.
For next week, actually, pre-trial today.
I thought it was, but it showed on the docket today, trial. I was,
Well, somebody got it wrong. So I wrote down pre-trial today with the trial next week.
I think we have a resolution.
Okay?
May we approach your honor?
Yes.
They'll be down for a year.
Maybe 6 months. Suspension. Go back. Scott, where are you in treatment now?
I'm at Hometown Recovery with Deidre Edmonds. She seems to be real nice lady. You know,
Good.
get along real well. She's seen her a couple of times in the last couple of weeks, and she's
Good.
surprised me.
You got to do the plea first, then he's not going to send you to jail, Dave. He wants to make sure you keep doing it. You're going to, right? Okay. Judge, based upon my discussion with the counsel for the state of my client, it's my client's intention at this pretrial hearing to change his plea to guilty to be a first offense OVI charge. The prior charges were reduced to physical control, so it would be a first offense. We would ask the sentence be delayed. He keep his appointments with Hometown Recovery and come back and basically monitor rather closely his progress in the program. He indicates to me he's excited about it. He's going to do it, right, Scott?
Mr. Taylor, do you agree with what Mr. Smith has told the court?
Yes, sir. Yes, sir.
Okay. All right, I'm going to accept your guilty plea. I'm going to delay the sentencing, give you a chance to go to finish treatment at hometown and see what you do and kind of monitor that. And the better you do in treatment, the better I can do on the sentence. Okay?
Okay.
So,
I just say one thing before this all closes out. I don't want to be derogatory. My only escape for the last 7 years has been a little bit of alcohol, you know. At food fair the night, my groceries were packed in the trunk. And I'd already went in the store and got the groceries for Mom. And so, but you know, I was just exhausted on all these bins that, you know. And, but I'm sorry, what was that?
We'll get it fixed.
27.
Hang on a second, we're not done yet.
okay, and I understand. My concern is that for yourself, for your safety and other people out on the highway, if you are out driving, which I don't think you should be at this point. So let's come back and I'll monitor this. It'll be a sentencing hearing, but I probably won't sentence you. I'm just going to monitor for a while to make sure you're doing what you're supposed to. Can we, let's see, let me check that date. I know you're here March 3rd, right?
March 3rd and 10th, Judge, either one.
I just say one more thing. Okay.
You're good.
All right, I'm sorry. I just want to say, you're trying to keep me mind.
I understand, we understand. That's what we're getting at.
Oh, okay. We got a lot of stuff loaded on there. We'll have to probably move a lot of the stuff on the 10th. How about, you're not here March 6th?
Might be, Judge, I was looking at Fridays, that's a Monday, I probably could be.
March 6th is much better.
It's busy, let me see, I should. I am scheduled for a jury trial, Judge Ballard, the 6th and 7th. I am here Friday the 17th or Monday the 13th.
We'll do the 3rd, March the 3rd.
Okay.
Bring your lunch.
And Judge, I did have a very limited driving privilege to go to treatment with the court for these hearings and then his medical appointments. If that's Mr. Hill's line.
If the state agrees with it.
Yeah, approach.
We do, but I would also like to say that, Your Honor, we are aware that Mr. Taylor's had some difficulties, and we've tried to help him address those in prior times before the court, and we're really concerned at this point that he's going to follow through. Hopefully the treatment that he's seeking is going to be beneficial to him, give him somebody to talk to, which may be what he really needs. And we can't have any further violations because we would have to insist on a bunch of jail time if we had any problems whatsoever.
He's aware, Your Honor. We've had that same discussion. He understands this is very serious, and he's taking it seriously this time, correct?
Yes.
Okay.
All right.
Thank you, Judge.
March 3rd.
State of Ohio versus Lori L. Banks, case number CRA 20-231.
I don't believe Lori Banks is checked in, Your Honor, but I believe the state's just going to dismiss it to the grand jury anyway.
That's correct, Your Honor.
Okay, the case will be nollied to the grand jury.
State of Ohio versus Shannon Childers, case number CRA 22-417 A and B, and CRB 22-419.
She is on Blue Jeans, Your Honor. Also sent you a copy of her completion letter from the Recovery Center in Lancaster. So you should have got that. I sent it by text, so I don't know if you saw that or not.
I have not.
Make sure it went through. Yeah, it went through. Half an hour ago.
Okay, I do see it.
Did you say you?
I do.
Oh, you do, okay.
How does the state want to proceed?
I'm assuming then that she received a certificate stating that she completed that treatment program. And it looks to me like, oh my golly, there it is, okay. Every one of her reports that was reviewed by the court since the beginning of this case back in June, it looks like they've all been good reports. She's stuck with the same program, and
Yes.
she's completed it.
Yes.
So that sets her apart in some respect anyway. So we wouldn't have an opposition to a dismissal of the charges at this time. I believe she's fulfilled what we expected of her.
So that would be 22-419 was possession, or 417 was the possession. There was a B too.
I thought they both were possessions, but maybe,
And then there was a 22-419 drug paraphernalia. That, you wish that to be dismissed also?
Yes, Your Honor.
There was a traffic charge also. TRD 22-1747 A and B, driving under a suspended license and turn signal violation.
We wouldn't have a problem dispensing with the turn signal with a dismissal, but I guess the driving under suspension is going to need to be addressed.
so just a failure to reinstate on that, Your Honor?
Looks like it's a non-jailable type. It looks like it was for some sort of financial responsibility violation.
Your Honor, that's probably just going to be a fine. Shannon, you okay with pleading to that? Hopefully she's been able to
Since then, I have gotten my license back, and I pay on SR22 every month.
Yeah, maybe we should, here's the problem too, no proof of insurance. If I take a plea on this, she's going to wind up getting a suspension.
Your Honor, she's done so well. What does the court think about dismissing it all?
We don't oppose that, Your Honor.
Okay, so both charges, 22-1747 A and B, are being dismissed at this time. Our cases are completed.
All right, thank you so much, Your Honor. All right, you're all done, Shannon.
Thank you so much.
Good luck to you, ma'am. Keep working at your sobriety, though.
State of Ohio versus Jonathan Jarvis, case number CRA 2367. This was set for extradition hearing. It's not in our jail. I assume it's doing stuff.
All right, this was set just to ensure that he did get picked up by Kentucky. Apparently that did happen. He's no longer in the jail, so case here is dismissed.
State of Ohio versus Kimberly Schemes, case number CRB 16826.
All right, has the prosecutor seen this?
Does she have counsel?
She does not. She filed it herself.
I haven't seen it. May I approach?
Yeah. I think what we need, this was a subject of,
What is there, give it a copy in the box.
okay.
Whatever I serve them.
This was a subject of the judicial conference last week that I attended in Columbus. there's a mandatory 45-day waiting period from the time of filing. So it actually says expunge. I know she did this herself, but some of it says expunge, some of it says sealed. Those are two different things. So I'm going to pass this until, let's see, at least 45 days. This was just filed January 12th. So it's been filed 3 weeks now. I'm showing a case balance of $50 in the file. I don't know if that's correct. Can you look up 16826? Yeah.
That's the filing fee for filing the expungement. I don't know that it's showing a balance.
Was that paid, the filing fee?
Sorry, this.
I'm showing it from I'm looking at a review hearing summary from way back, that there was a $50 balance. So.
Yeah, that's an old review sheet, Your Honor. There were no fines and costs owing at the time she filed that.
Okay. And are you still living in Huntington?
Yes, sir.
Okay, I'm going to pass it to beyond the 45. That is mandatory under Ohio law. Actually, you're getting the brunt of me going to a seminar and finding out what the law is, because we haven't been doing that up until now, but that's mandatory under the statute.
She called me and gave me a date after I filed.
Okay. Well, the clerk didn't know either, so we're...
I had done a procedure, Your Honor, but I had also received an email from the Clerks Association. I guess that's something that there are new.
Yeah, I don't know if that was a change in the law, if it's always
as
been
of
that.
January 3rd. I think it's a new.
Are you working, ma'am?
Yes, sir.
Well, it'll have to be a Monday or Friday, which is better for your schedule.
Either or would work just fine.
Okay. And that'll give the prosecutor time to research this and see if they have any objections to it.
And actually, Your Honor, my very able assistants have already provided me with a copy, and it appears that we would not have an opposition to it. There's nothing to keep.
Okay, so then all we got to do is get past the 45-day mandatory waiting period. Okay, let's do February 21st. That's actually a Tuesday because the Monday is a holiday. So this will be scheduled for a hearing on February 21st at 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Zane A. Smith, case number CRB 2340.
And you're Zane Smith?
Yes, sir.
You have a disorderly conduct complaint filed against you alleging that January the 14th in Fayette Township, you recklessly caused inconvenience, annoyance, alarm to others by engaging in fighting, threatening to do harm to other persons or their property, being violent or turbulent, and that you persisted in this conduct after you were warned to stop. So that makes it a 4th-degree misdemeanor, maximum penalty, 30 days in jail, $250 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How you plead to this charge?
I really don't recall exactly what was going on.
Well, I'll enter a not guilty plea for you then. Do you want a lawyer appointed to represent you?
Yes, please.
Do you have a job?
No, sir.
You have no income?
No, sir.
All right, Mr. Morford, I'll appoint you to represent Mr. Smith.
Here's my card. Thank you.
Yes, sir.
Let's see, are you here the 13th? Did we already set something for you?
I believe so, Judge, yes.
February 13th would be the next hearing. Pre-trial, he can sign a 500, oh, he's got a bond up, I think. He has a bond up, so his bonds continue.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Michael Robbins, case number TRC 22-1266, or excuse me, 1566 A and B.
It's Mr. Green's case.
Hey, we approach Your Honor.
Yes. He has a medical appointment with the VA tomorrow. Take months to do a reschedule. Try to get it sooner rescheduled. I'm sure says that was, I think, November 28th. He didn't have a possession, it's just a OVI. I need a letter sometime before I can treat it as a first.
That's kind of background.
Come back in maybe 6 weeks.
Oh, Your Honor, can I put you on that?
Sure. Okay, it appears that Mr. Robbins is doing well. I have no indication otherwise, but I don't actually have a report today from the VA. The last thing that I had was in November that said he was going to be doing long-term. So I'd like to have a follow-up. I don't know what, it wasn't defined what long-term meant, but I assume he's still getting active treatment.
Yes, Your Honor.
So why don't we come back, say, mid to late March? What's your schedule, Mr.?
I'm available at that point, Your Honor.
Okay.
And I think I may have a copy of the last report as well, and I can make a copy of that to give to the court.
Okay.
That way we have it in the file for the future.
March 17th?
It's fine, Your Honor.
The on the docket is the 17th.
Thank you, Your Honor.
Thank you.
State of Ohio versus Naaman Cox, case numbers TRC 221663, A, B, C, D, and E, TRC 213062, A, B, and C, CRA 21500, TRC 211917, A and B.
Okay, I have Mr. Meadows as the attorney, is that right?
Yes.
Okay, it's a good report from the spectrum. I haven't heard anything from Mr. Meadows. Have you talked to him, Mr. Cox?
He mentioned to me something the other day when I called him on the phone. He said that he had a trial yesterday and was hoping to have it done in time to be here today.
Okay. What's your suggestion, Mr. Healy?
Well, what I would do is I'd go ahead and text him and let him know that we've had the hearing today and when we're coming back, so he'll know. It looks like Mr. Cox is doing what's been required of him so far, so we're encouraged by that.
Yeah, it was set as a sentencing hearing, but the report is favorable. So we'll just, your attorney's not here, so I'm going to continue it, and hopefully he can be here at the next hearing.
Okay.
Let's make it March 6th. March 6th will be the next hearing.
And, Your Honor, should I also let him know that if he needed to attend that hearing remotely, he could do that?
Yes, that would be fine.
Thank you.
Contact Mr. Meadows, sir.
State of Ohio versus Kevin Pine, case number TRC 222480, A and B.
Mr. Morford's case. There's a certificate of completion from prior days from yesterday.
Oh, 3-6.
Was there an agreement as to sentence recommendation with Mr. Pine's completed treatment?
Your Honor, we, first of all, wanted Mr. Pine to do what he has done, and that is obtain a certificate that he's completed a substantial treatment program, and he's actually been at this for quite some time and achieved that. The charge was a first offense high score, and because of his compliance and efforts, plus the fact that there were probably some minor difficulties in proving the case, we were agreeing to recommend a treatment as a first offense low score if he was successful. So we're able to do that.
Mr. Morford?
We would join in that recommendation, Judge. I'd also point out he has suffered loss of employment as a result of this. You'll recall he was driving an Armstrong van, and they terminated his employment as a result of this accident.
All right, Mr. Pine, anything you wish to say before sentencing?
I'm sorry that I did that. I could have killed somebody, I could kill myself, could have killed somebody else, and with that thought, doing that, I never want to be in this position again.
Okay. Thank you for your statement. Okay, I'll allow the reduction to be considered a first offense, low test score, right? Which means there's no mandatory jail. With a high test score, there's mandatory jail. So I'll impose a $500 fine, order you to pay the court costs, 20 days in jail, all suspended, 5 days of community service. Is the state willing to, you still want him to do the dip school since he completed treatment, or how do you want to do that, Mr. Hill?
I believe that the treatment that he's gone through is sufficient to stand in place of the dip school.
Okay, that's the driver intervention program. So will not require that. His review hearing will be September 5th. September 5th. You're to meet with Mr. Major in the probation office. You got 5 days of community service. You can do any day but Sunday or a holiday. What about driving?
We get that last time.
I believe that you granted that earlier, Judge.
Well, I'll have to do it now. I have to redo it if it's going to be post-sentence. So I'll allow him to have driving privileges for work, for community service. Anything else?
Kids, doctor's appointments, school.
Transport.
For child care.
And then, even though I've completed the program for treatment, they've told me that I can still come back. So when days I'm able to, I am going back to treatment.
Okay, for counseling. I appreciate it. You'll get that from Mr. Major. You're going to meet with him, sign up for probation, he'll give you your permit for driving. Any other questions?
Thank you, Judge.
Good luck. See you, Mr. Major. You're
Thank you, sir. Good luck.
State of Ohio versus Melanie Yap. Case number TRC 191681, A, B, and C.
This is Mr. Smith's case.
Melanie Yap.
I think it may be on because she had a bond. She had been doing a lot better, too.
Your Honor, if I may, she did call me yesterday and say she wasn't going to be here, something to do with her child. I advised her that she had 7 days before warning to go out.
All right, well, she'll show up. I was thinking maybe she had. I don't see it. I guess she didn't. I thought maybe she had a bond up, but I don't see it. Okay, she's got 7 days before her warrant issues.
State of Ohio versus Jennifer Collins. Case number CRB 24, A and B, and TRC 194073.
Thank you. Your Honor, this is my old case. You had me stand up last time, so it's set for sentencing.
And she does have a bond up, so that's why I said as a sentence just said, it reminds me that she has a bond. She has community service and bonds and costs to pay. She did finish the 3-day program, did that
Right.
in December. So, do you have a payment on your fines today?
Yes, I can make a payment today,
How much?
30.
You got community service to do, when you gonna start doing that?
I've got Thursdays back off, so I can get it done these next few Thursdays.
Okay. And I'll get out here on Thursday, I'll see you, next review's March 3rd.
I'll have it done by then.
If you do, you don't have to come back. Finish everything, you don't have to be here.
All right, thank you.
March 3rd.
Yeah, sentencing. March 3rd at 10 o'clock for sentencing. She
Thank
has
you.
a bond now.
All right, thank you.
State of Ohio versus Kelly Mintz, case number CRB 2366 and CRB 18326.
So this was a review that was set Monday, I guess it was.
Yes.
You did make a payment today. You got community service and fines still to pay, so get that done. Your next hearing will be March the 6th. And that's a review, so it'll be at 9 a.m. March the 6th.
Okay, thank you.
State of Ohio versus Ethan R. Anderson at the Lawrence County Jail, case number CRB 2319.
Your Honor, he has been indicted on felonies. We're not so sure exactly what they are.
Arson.
Arson. So I think the prosecutor just wants to continue this to see.
Better than I deserve. I'm not in jail, so that's always a good thing.
Yeah. You're glowing today.
So, we get to this case, it's this one, if you- that's what-
Just continue this.
How do you want to proceed?
Your Honor, we'll just continue it to another day until they have some information on the felony case. I guess that's what they want to do.
He has been indicted, so you have any idea when he would be arraigned on the indictment?
Well, we think maybe next Wednesday, but we don't know for a fact.
Come back on the 10th? then?
Yes, that's fine.
All right, next hearing is February the 10th. 10 o'clock.
All right, thank you, Your Honor.
State of Ohio versus Jonathan Morris, case number CRA 22531 A and B. And Austin Deese is on deck.
What's the one, the piece here on there? What's the preliminary?
It's Donovan Spears.
All right, we're not getting a video from the jail, we're only getting audio.
Video, so you're not getting video.
I'm sorry?
He's looking right now, the video.
Okay. It looks like it's turned off there. It's not turned off on my end, it's showing it turned off on the jail end. There we go. Okay. Sir, you Jonathan Morris?
Yes, sir.
I'm Judge Capper at Lawrence County Municipal Court. I'm going to start this.
Yes, sir.
Recording has started.
This is your arraignment hearing, and before we start that, I want to give you your rights. You have a right to remain silent. You don't have to say anything. If you choose to make statements, what you say is on the record. It can be used against you. You have a right to have a lawyer, to have one appointed, if you can't afford one, to make the state prove the charges beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
First charge is tampering with evidence. That's case number 22531A. It alleges August 4th, 2022 in Union Township, knowing there was an official proceeding or investigation in progress or likely to be instituted, you altered or concealed a thing with purpose to impair its availability as evidence. That's a felony of the 3rd degree. The maximum penalty on that is 5 years in jail and a $10,000 fine. The B case, 22-531B, alleges same time and place. You knowingly cause physical harm to property owned or possessed by the Lawrence County Community Corrections, and that property is being used by Lawrence County Community Corrections in their business or profession. So that's vandalism, a felony 5, maximum penalty is a year in jail, $2,500 fine. You understand these charges?
Yes, sir.
Do you have the money to hire a lawyer?
No, sir, at all. I had one for, it was,
Tyler Smith?
Tyler, right.
Those charges are probably still pending, aren't they? I think this was
Yes,
for
sir.
cutting off for ankle monitor, so the other charges are probably still there. So it makes sense
Yes,
to
sir.
appoint the same person.
Oh, I can't hear it.
I'm going to appoint the same lawyer to represent you on these. So it'd be Tyler Smith. Will be appointed as your lawyer. When did you come into the jail, Mr. Morris?
I've been arrested since, December, the 30th, when, right after my old lady passed away.
Well, sounds like you spent some time in Western Regional, is that right?
Yes, sir.
Okay, because it takes them about a month to get you processed and sent over here. When did you get to Lawrence County? When did you get home to the promised land here in Lawrence County?
Back down here, I got down here, 3 days ago. Been Tuesday, I believe.
Okay, so on January 31st. So we can do the preliminary next Friday, on February 10th. I'm setting your next hearing for February the 10th at 10 o'clock. I suspect he has a holder on the other case anyway, so it's probably academic, what we set the bond at. What's your request?
Well,
I don't have no idea. I got an order now. I don't think so.
just to make sure, we want a $50,000 cash or surety.
I'm setting your bond at $50,000 cash or surety. Your next hearing will be a week from today in this court. So if you do make bond, you have to come to the court in Chesapeake on next Friday, the 10th, at 10 a.m. If you're, obviously, if you're still in jail, I'll see you on the monitor like we are today.
I'll see you next Friday.
Okay.
Jailer, the next case we're going to do is Donovan Spears. State of Ohio versus Donovan Spears, case number CRA 2370, A and B.
This is set for a preliminary hearing today, and Mr. Morford is the attorney. He's here in court. Mr. Spears, as I understand, is in the jail and will appear by telephone. And we are going to take evidence on this, I understand.
I believe we are.
Yes, Sir, you're Donovan Spears? All right, Mr. Spears, this is your, what's called preliminary hearing today. Your attorney is in the courtroom with the prosecutor. This is a probable cause hearing for the court to determine if there is probable cause to hold your case for consideration of the grand jury for indictment. So the state will have to go forward with evidence. Are you prepared to do that, Mr. Hill?
We are, Your Honor.
Call your first witness.
We'll call Investigator Chaffins from the Lawrence County Sheriff's Department.
All right, you can come up and raise your right hand. I'll swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth so help you God?
I do.
You may be seated. And Mr. Spears, can you hear the proceedings so far?
Yes, sir.
And you can see, I assume there's a television monitor there where you can see what's occurring?
Yes, sir.
Okay. Mr. Field, you may proceed.
Thank you, Your Honor. Are you Brian Chaffins, investigator with the Lawrence County Sheriff's Office?
With the Lawrence County Prosecutor's Office.
Prosecutor's Office, well, there you go. We work in the same office. Right. Sorry about that. I'm not there very often. In your work there with the Lawrence County Prosecutor's Office, did you have occasion on or about January 25th, 2023 to have contact and some dealings with Donovan S. Spears?
I did.
Did that take place in Chesapeake, Ohio, in Fayette Township?
Yes, 311 Township Road 1156.
And are you familiar with Mr. Spears, and would you be able to point him out on the screen here in the courtroom?
Before it got fuzzy, you knew the individual on the right there.
Ask that it be noted in the record that he's identified the defendant.
You identified Mr. Spears.
Could you explain to the court what your dealings with Mr. Spears were?
On January 25th, I applied for a search warrant for the residence of 311 Township Road 1156, Fayette Township, which was granted. Myself and other investigators went to the residence to execute the search warrant. Inside the house, we found, first thing we done is we knocked, announced ourselves, ordered everybody to come out of the house. Mr. Spears came out first, followed by a 3-year-old daughter, and then eventually his girlfriend come out as well. Her name is Kaylee Wilson. Once everybody was out of the house and secured, we searched the house to make sure that no one else was present. And investigators then went in and began photographing and searching the residence.
And what did you find during that search?
During the search, there was a number of things found. The most notable being 6 firearms, approximately 3,000 grams of liquid hash concentrate that was in a freezer in the garage, and approximately 2,500 tablets that are marked as M30, which is, in the pharmaceutical world, that would be an oxycodone 30 milligram. However, these were not consistent from bag to bag. They were slightly different colored, and they had slightly different consistency of the powder. Based on my training and experience, they appeared to be pressed fentanyl tablets.
Now, the amount that was seized, do you have an idea about approximately what that would amount to?
It's approximately 22,500 unit doses.
Okay, and that is enough to make it a first-degree felony level?
Yes.
And the hashish, that was in a liquid form?
That's correct. Well, at room temperature would be liquid. That's why it was in the freezer.
I see. And that was an amount that, with the presence of the juvenile, makes it a first-degree felony. Is that correct?
That is correct.
And likewise, it's a first-degree felony because of the fact on the fentanyl charge as well. Is that right?
Yes.
Did you interview Mr. Spears with respect to this, the finding of these drugs?
I did.
And did he make any kind of statement to you that might incriminate him?
Yes, originally I surreptitiously recorded the conversation between me and him. It took place in the front of my unmarked patrol vehicle. He signed a written Miranda waiver and agreed to be questioned. During the course of the interview, he admitted originally that there was going to be about an ounce of marijuana and $1,000 cash or an ounce of marijuana and $2,500 in cash in a kitchen cabinet, that there would be $1,000 in cash under the bed in his bedroom, or he described as being his bedroom, which is the same bedroom where the firearms were. So while I'm interviewing him, I took a pause to talk with the search team to see what they had uncovered. By this time, they had found the approximately 3,000 grams of hash oil in the freezer. I began talking to him about that topic, and he said that he had forgot about it, that it had been delivered from an individual in Chicago, that he'd had it for about a year. And there was also, he told me we would find a small, they were pressed down in like, the best way to describe it was taking rock candy, putting parchment paper down and a cookie sheet, because all this stuff was there.
then you would pour the liquid onto the parchment paper, fold it, and then you'd stack it in these sheets in the freezer, and that's how it was stored. Inside the freezer inside the house was one of these same sheets, but it was probably about 3/4 consumed. So while I'm talking to him about this new discovery, the search team then informs me that they found even more stuff. In a large black duffel bag just outside the back door was approximately 1 pound of vegetative marijuana, along with the 2,500 fentanyl tablets. The tablets were marked, each bag was marked as 1,000. It had it written on the bag. And when we finally counted them, one bag had 1,000 in it, one had 800 and some, another one had 600 and some. But even though they had the markings like the FDA would require for an oxycodone 30, they were clearly different colors. One was almost a green shade, the other one were 2 different shades of blue, and some of them were starting to crumble and come apart. I interviewed him about that. He admitted that he knew it was there, that the same man that he'd been ordering these deliveries of drugs had sent it to him, and that he had sold it on occasion. And that the reason it was on the back porch is because that's where his roommate, Devin Chin, stored it.
This address where this took place, 311 Township Road, 1156, Chesapeake, was that Mr. Spears' address? So this
Yes, that was his
residence?
DMV registered address in Lawrence County.
And what you've described as far as how and where you found and the quantities that you found, are those indicative of trafficking to you?
Absolutely.
And in case I didn't ask you this before, it did happen in Fayette Township in Lawrence County, Ohio, is that right?
Yes. It's also commonly known as Opal Drive.
That's all I have, Your Honor.
Mr. Moore?
I didn't hear you. Did you give Mr. Spears Miranda before he started questioning?
Yes, he signed a written waiver.
He signed the waiver?
Yes.
The firearms, were you able to determine if they were legal? Were they owned by a particular individual or individuals?
I don't know who the owner was, but none of them were stolen.
Okay. Don't know who they're registered to?
Ohio doesn't register guns.
Okay. Federals do though, don't they?
Not the gun per se. When you go fill out a background check, you fill out whether you're wanting to buy a long gun or a handgun. The facility where you purchase it at will store the exact firearm that was sold to you. They don't track them, the individuals, the exact serial numbers and types of firearms. Or models, just whether it's a long gun or a handgun.
Okay. Did you seize a cell phone belonging to Mr. Spears?
I did.
Did you dump it yet?
No, I have applied for a search warrant for it as well, and it is at the ONIC lab in Columbus pending extraction.
You have that in your possession?
The
cell phone?
No, it's at the ONIC lab in Columbus, Ohio Narcotics Information or Intelligence Center.
Okay.
They assist us with these type of investigations.
Now, did you do any kind of test to identify what you call liquid hashish?
Yes, we done a field test for THC, which showed a positive indicator.
And these were, tell me again how they were prepared.
It looks like honey, like if you were, and that's about the consistency of it when it's at room temperature, but it was poured out onto these, they were sheets about the size of this sheet of paper, baking sheets. It looked like it had been poured out so it was flat and level, covered with parchment paper, and then stored. There was a stack about this tall of them in the freezer. And we weighed one of them, come up with an approximate 80-gram weight times the total of 37 sheets, which is going to be roughly in the neighborhood of 3,000 grams.
Was the whole sheet of paper covered with a hash?
Yes, it was made to fit whatever the original container was.
Do you know if Mr. Spears has any priors?
I don't believe that he did. I don't believe he had any prior convictions.
How did you come out to get a search warrant at this address on Opal Drive, Investigator Chaffins?
It was in part from information that was forwarded to us by the Irving, West Virginia Criminal Interdiction Unit, where they made a traffic stop where they intercepted the shipment of 16 pounds of marijuana.
And as I understand your narrative, that shipment was destined for Opal Drive?
Yes,
And that's how you got on to
that was part of our investigation, yes.
part of it. Were any other arrests made as a result of your investigation, sir?
Not this time.
Have you had his interview reduced to writing yet? Transcribed?
Transcribed, no. I have a synopsis that I have written of the interview. But no, the interview between me and him has not been transcribed. I believe it was.
Which judge? I'm sorry.
It was kind of lengthy. Because we had to keep talking about new topics.
Which judge issued your search warrant?
It was Judge Ballard.
That's all I have, Your Honor.
Any redirect?
No, Your Honor.
You may step down, thank you. This is witness discharged.
Yes, Your Honor, we rest.
Thank you. Any evidence from the defendant?
No, Your Honor, but I've been asked by the family who has some money for bond if you would consider a reduction in bond. I don't think Mr. Hill supports that. But
We do not support that, Your Honor.
Well, what type of bond do you think they could make?
That's what we got right now.
Judge, they believe if you would modify the bond to $50,000, that they could come up with $5,000 for bail bondsman.
We're in opposition to that. This, the danger presented by the amount of drugs that were involved in this, and it's indicative of a deep involvement in drug trafficking that we feel we need to protect the public from at this point.
All right, I'll deny the motion.
Thank you, Judge.
The case is bound over to the grand jury.
State of Ohio versus Austin Neese. John Suter is on deck.
You used to work at the sheriff's department,
For about 16 years.
yes, but
I've been working there for about 2.5.
I'm never there.
Case number is 2385 and 86. All right, sir, are you Austin Neese? All right, Mr. Neese, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. Everything we say is being taken down. Your image and voice are being recorded. You are appearing in the courtroom on a television monitor. You don't have to say anything. You have a right to remain silent. If you choose to make statements, what you say can be used against you. You have a right to have an attorney appointed if you can't afford one. You have a right to bail and to make the state prove these charges beyond a reasonable doubt. Do you understand those things I just explained to you?
Yes, Your Honor.
Those are your rights. Okay, first charge, case number 2385, alleges that on February the 2nd of 2023, in Fayette Township, you knowingly were transporting or had a loaded handgun in a motor vehicle, and while you were transporting it, you were under the influence of alcohol or drugs or a combination of those things. So that's improper handling of a firearm in a motor vehicle. It's a 5th-degree felony. It carries a maximum penalty of 1 year in jail, $2,500 fine. 2386 case number is an allegation that you committed aggravated menacing. That on February 2nd, Fayette Township, you knowingly caused Ethan Collins to believe you would cause serious physical harm to his person or property, that's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. So those are the two charges. Do you understand the two charges?
Yes, Your Honor.
There's no OBI, or is there an OBI coming?
I am looking to see.
Okay.
It seems like there ought to be, but I don't see
You
it.
would, kind of seems logical from the other charge.
Well, I wasn't driving the motor vehicle, Your Honor.
That might be.
Okay. Do you have the money to hire a lawyer, Mr. Neese?
Yeah.
Okay, you don't want me to consider you for a court-appointed lawyer?
No, I'm looking.
Okay, you have a right to have a hearing within 10 days of your being arrested, which I assume was yesterday. So that I will set your hearing for next Friday.
Well, one thing I was gonna ask, Your Honor, is if, is there any way I can post bail or bond?
Well, we're going to consider that next. What's the state's position on bond for Mr. Neese? And I've got a Pedro address for you.
No, that is not accurate. I've never looked up Pedro. I think there was something wrong with the system over here, because one of the COs had also said something about that. I live out in Boyd County with my grandparents.
What's your correct address then?
7327 State Route 5, Ashland, Kentucky, 41102.
What's the name of your grandparents?
Donald Arthur and Donna Arthur.
What's the state's position on bond?
Your Honor, having read the officer's statement, the affidavit along with these complaints, pretty serious sounding situation, we would request a $25,000 cash surety bond and a protection order.
Okay, I'm going to set your bond at $25,000 cash or surety. You can use a bail bondsman. Do you want to talk to a bail bondsman?
I'm pretty sure I have someone present in the courtroom that's going to talk to him for me.
Okay, so you wish to talk to a bail bondsman, ma'am?
Yes.
What's your name?
Katrina Harrison.
Trina Harrison, okay. Bailiff will get Mr. Sowards, our local bail bondsman, will get in touch with you. Is that a bond you think you can post then?
It's 10%.
Yeah.
It's 10% of that, correct?
Yes, okay.
It'd be nice if we could knock it down just a little bit.
So, do you want, you have a right to have this hearing within 10 days, but I can go longer if you want longer.
I'd rather go longer just so I could get all my ducks in a row and hire an attorney.
Okay. How much time do you think you need to get a lawyer?
20, 30 days just to get everything situated.
Okay, let me check the schedule.
If that's too long for you, sir, 10 days is fine. I don't want to be a hassle.
Oh, I'm here regardless, so it doesn't matter to me. I'm going to be here whether you're here or not.
Okay.
Let's do the 27th of February. And you're sure you're going to be out of jail? I don't want you sitting in jail that long.
I'm not going to be in jail now.
Okay. February 27th will be your next hearing. It will be at the municipal, well, she knows where it is. She can get you here. It's at the municipal court in Chesapeake, Lawrence County Municipal Court. You have to be here February 27th at 10 a.m. with your lawyer.
Yes, sir. Yes, sir.
Do you have any questions, sir?
No, sir. I appreciate it, Your Honor.
Okay, you're welcome.
And Your Honor, I've put a notation here that he agreed to waiver of time for that period.
Yeah, it's on the record.
Okay.
State of Ohio versus John Suter, Case number CRA 2383 A and B, CRB 2384,
Yes.
and TRC 23105. Mariah Nikoloff is on deck.
Are you ready on Mr. Little?
Yes.
Okay, Mr. Little, you can come up while we're waiting on the next one that's on the jail. And we need Little. Corey Little.
State of Ohio versus Corey Little, case number CRB 22491 and CRA 22405.
And I was going to let the state get their file and maybe talk to Mr. Holt.
I spoke with Mr. Holt, and he asked for the case to be reset for this coming Monday, the 6th, and we don't oppose that.
All right, I'm going to continue your case to the 6th. You've got a bond up. Well, in fact, I'm going to have you sign a new bond.
Are you talking to me? I couldn't, my headset went on, I couldn't hear you.
I'm dealing with another case, sir. I'll get with you in just a minute.
Oh, I'm sorry.
Okay, so let's make Mr. Little's bond, new bond, 5,000 cash assured. Or, I'm sorry, 5,000 OR. 5,000 signature bond. So I'm upping the ante. If you don't show up, you're going to owe 5,000, not 1,500. So you got to be here, back here Monday. The 6th at 10 a.m. And you should contact Mr. Holt. You have his contact information.
I tried to contact him before, Your Honor, to let him know I wasn't going to be at court when I missed my court appearance, and nobody ever returns my calls. I've left quite a few voicemails for them.
Do you have a phone number?
Yes.
Okay, I suggest you call it as soon as you leave court. Supposedly he is going to be here Monday. Is that correct, Mr. Keel?
Yes, Your Honor.
He will be here Monday.
Okay.
That's all. You're free to go.
All right, thank you, sir.
Okay, so this gentleman is John Suter. You're John Suter?
Yes.
Are you representing him, Mr. DeWater? Mr. DeWater, you're representing Mr. Suter?
I'm sorry, yes, Your Honor. I just spoke with his family this morning. I spoke with Mr. Suter very briefly on the telephone prior to coming into court here today.
Okay, I'll put you down as counsel of record. And you received a copy of the charges?
Yes. We'd waive a reading of the charges, Judge, and waive any defects in service of the charges. And for purpose of the misdemeanors, enter not guilty pleas today.
Okay. What's the state's position on bond for Mr. Suter?
Your Honor, we would, what did we say?
It's a possession charge is the most serious, it looks like.
All right, so our request,
Well,
Your
there's
Honor.
trafficking in here too.
Yes.
It's the same. It was a traffic stop, Your Honor, allegedly, and there are two charges based on the same allegations.
Our request is for a $25,000 cash or surety bond plus GPS.
Well, that won't happen till Monday at least. You know that. Unless you've got some influence that I don't have.
I doubt that I do. I can try to make that happen, but I don't know that I'll be able to do that before Monday.
Okay.
I will be here, though, on Monday, Judge. I got several other cases with
We'll
you.
just put it back on the docket then.
Yes, sir.
All right, I'll set bond for Mr. Suter at $25,000, cash or surety, plus have you already talked to Mr. Sowers, or?
Mr. Suter's family has.
Okay, plus GPS monitor. And and put it on the docket for Monday, which is the 6th, February the 6th. But we're not actually having a preliminary hearing then, right? We'll just review bond then,
Yes, that'd be fine.
and pretrial on the misdemeanor. Anything else?
No, not today, you're good. And then, John, I'll call you in a little bit, or come over there, okay?
Okay.
Okay, that's all.
Thank you, Ron.
State of Ohio versus Mariah Nikoloff, case number CRV 2382.
Hello?
All right, Ms. Nikoloff, I can see the top of your head, is all I can see.
Sorry. You see me?
Maybe pull the camera down or something. Or sit up. There we go, now I got you.
Okay.
I think you know who I am,
Yes.
and you know where the court is,
Yeah.
and you know your rights, but I gotta tell them to you. You have a right to remain silent, you don't have to say anything. You have a right to have an attorney appointed if you can't afford one, to have bail, to make the state prove the charge against you beyond a reasonable doubt. Do you understand those things?
Yes.
You got a theft defense from Walmart. State's alleging that you tried or did take property from Walmart without their consent. It's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
How do you wish to plead to it?
Not guilty.
Do you want a lawyer appointed to represent?
Actually, I don't know how to do this. I just know that I was going to see if I was eligible for a bond.
Well, we're not.
I was,
Well, of course you're eligible for bond. The only thing I cannot bond people on is capital murder. And I don't think you committed that, so you're gonna get a bond. But I gotta get a plea from you first. What's your plea? How do you plead?
not guilty.
And you want a lawyer?
Yes.
Do you have a job?
No.
You have no income?
No, not right now.
Do you have any other cases pending anywhere?
No.
Okay. Let's set it for the 13th of February. I'll let you out on a signature bond of $1,000.
Does that mean no more?
Yeah, OR, your own recognizance.
Okay.
You gotta be in court on February 13th
Okay.
for a pretrial. And I'll appoint Mr. Morford, because I know he's gonna be here that day.
Okay, thank you, sir.
Okay, February 13th will be your next hearing,
What time?
10 a.m.
10 a.m.?
Yes.
Okay, is that it?
That's it.
All right, thank you, sir.
You're welcome. Okay, that finishes us out at the jail, I believe.
What is it?
We're finished at the jail. You can tell the jail.
Oh, okay. Okay, all right, thank you. I'll tell them.
Okay, anything else? We're finished everywhere. Court's adjourned. We need to, once you shut it down, let's try to reboot it, because it used to, I could control all the cameras that are there from here. And now it's not.
When I log out, just Bluetooth that right here.
Yeah.
Anything you need from me out of those?
Well, I don't think so. That's pretty fine.
Tell them what's wrong with it, because I'm taking your chair away, it's a big problem.
The video, the morning video, and the Bluetooth app both disappeared as soon as I shut it down.
You saw it putting on the
And then
Lucas back.
Mr. Major knows where to find that.
You saw
He
it
goes
putting on the
in and
Lucas
back
and
there.
that dog
Okay.
chained to the fence, okay. I haven't had time to do this, press a piece
Well,
of it.
apparently they're not in sync now, because I can't, initially when it was set up, I could control that screen from this screen, and now I have no control over that screen. It's just doing its own thing.
Makes me so happy I could sing a song, Sarah.
Fix that, they screwed that up.
So